ಆಕ್ಷನ್ ಆದ್ಮೇಲೆ ಸೇಲ್ ನೋಟಿಸ್ ಏನು ಬಂತು? ಕನ್ಫರ್ಮೇಶನ್ ಆಫ್ ಸೇಲ್. ಎಷ್ಟಿದೆ ಡ್ಯೂ? 230. ಗಿವ್ ಇಟ್ ಎಸ್. ಮಂಡೇ ಏನದು? ಅದಕ್ಕೆ 230 ಯಾಕೆ? ವೈ 230? ಟುಮಾರೋ ಎಸ್. ಏನು? 230 ಮಂಡೇ ಹಾಕ್ಬೋದ? ಅದು ಇವ್ರದ್ದು ಮಂಡೇ ತಗೊಳ್ಳಿದ್ದು ಅರ್ಜಿ. ಮಂಡೇ ಪೆಂಡಿಂಗ್ ಅಂದ್ರೆ ಮಂಡೇ ಬರಲ್ಲ, ದಿನ ಬರುತ್ತೆ. ವಿಲ್ ಸಿ. ಎಸ್. ಮಂಡೇ ಆಗ್ಬೋದಲ್ಲ ಕೊಡಿ. ಮಂಡೇ ಇಸ್ 4th ಅಲ್ಲ, ಮಂಡೇ ಏನು 7 ಸಾರಿ. ಎಸ್. ಮಂಡೇ ತಗೊಂತಾ ಇದೀವಾ? ಕೊಡಿ, ವಿಲ್ ಸಿ. ಗಿವ್ ಇಟ್ 4th ಹಾಕಿ ಮೇಡಮ್. ಪೆಂಡಿಂಗ್ ಆರ್ ಫ್ರೆಶ್ ಮೇಡಮ್? ಮಂಡೇ. ವೆನ್ 230. ಎಸ್. ಇದು ನೀವು ಕೂತ್ಕೊಂಡು. ಅವರು ಕೂತ್ಕೊಂಡು. ಎಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಗಿವ್ ಇಟ್ ಕವರ್ಡ್. ಎಸ್. ನೆಕ್ಸ್ಟ್. ಪೆಂಡಿಂಗ್ ಮಂಡೇ ಬರಲಿ ಬಿಡಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್. ಮಂಡೇ ಇದೆಯಲ್ಲ, ಒಂದರಷ್ಟೇ ಕೊಡಿ. ಏನ್ ಯುವರ್ ರೆಸ್ಪಾಂಡೆಂಟಾ? ಮತ್ತೇನು ಮುಂದೆ ಎಲ್ಲ ರೌಂಡಲ್ಲೂ ಒಬ್ಬ ಇದ್ದೀರಾ, ಒಂದು ಮೆಮೊ ಇಟ್ಕೊಂಡು ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್. ನೋ. ಎಲ್ಲಿದೆ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು? ಇವತ್ತಿದೆಯಾ? ಮತ್ತೆ ಎಸ್. ಸುಮ್ಮನೆ ಮೆಮೊ ಮಾಡ್ಬಿಡಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್. ಅದು ಬರಲಿ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್. ಮಂಡೇ ಜನರಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ. ಆಲ್ ಜನರಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ವಿಚ್ ಕ್ಯಾನ್ ವೇಟ್ ಟಿಲ್ ಮಂಡೇ ಪ್ಲೀಸ್ ಗಿವ್. ಪೆಂಡಿಂಗ್ ಅಲ್ಲ, ಫ್ರೆಶ್ ಫಸ್ಟ್ ಕೊಡಿ ಎಲ್ಲ ಮಂಡೇ. ವಿಡ್ರಾಯಲ್ ಇಮಿಡಿಯೇಟ್. ಒಂದು ನಿಮಿಷ. ವಿಡ್ರಾಯಲ್ ಯಾವುದು? ತಗೊಳ್ಳಿ. ವಿಡ್ರಾಯಲ್ 230 ಹಾಕಿ. ಪೆಂಡಿಂಗ್ ವೇಟ್ ಮೇಡಮ್. ವಾಟ್ ಇಸ್ ದಿಸ್? ವೇಟ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಆಯ್ತಾ? ನಿಮ್ದೇನು? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ನಥಿಂಗ್ ರಿಮೈನ್ಸ್ ಅಂಡ್ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಗಿವ್ ಇಟ್. ಥ್ಯಾಂಕ್ ಯು. ಅದು ನಥಿಂಗ್ ರಿಮೈನ್ಸ್ ಅಂತ ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಎಸ್. 14 tomorrow. ಎಸ್. ಸೇಲ್ ಆಗೋಗಿದೆ ತಾನೆ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಮಂಡೇ ಕೊಡಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಂಡೇ ಏನಿದೆ? ಆಯ್ತು, ನಾಳೆ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಗಿವ್ ಇಟ್ ಸರ್. 230 ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್?
ಏನಿದು?
File an appeal. File an appeal, sir, before the appellate authority or tribunal, whatever. So ಅದಕ್ಕೆ writ petition is the remedy. File an appeal, sir. Anyway, ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ಡೆಂಟ್ ರೀಚ್ ಕಾಂಟ್ ಹೆಲ್ಪ್. ಗಿವ್ ಇಟ್. ಡೇಟ್ ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್ಲ 230 ತಗೊಳ್ಳಿ. Give it. 2:30 and urgency la kodi. Tomorrow. Monday. 4 ಸರಿ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಮಂಡೇ. That is further hearing matter, sir. It's not a fresh matter. Friday ಹಾಕಿದೀನಿ, ಮತ್ತೆ ಯಾಕೆ ಮೆಮೊ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? Hey, that's all right. Friday I have asked them to post all fresh further hearing matters. That's a parted matter. Then leave it. Yes. ಅರೆ ಬೇಡ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದೀರಾ ತಾನೇ ಮೆಮೊ? Every day you go on giving memos of the same case. Yes. ಒಂದು ಕೊಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಎಲ್ಲ ಫಾಲ್ಸ್ ಅಂತ ಒಟ್ಟಿಗೆ ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ. Yes. Everything is false. ಕೊಡಿ. Let me see. If something is false, we will send you to the false. Yes. ಕೊಡಿ. Pending matters ಕೊಟ್ಬಿಡಿ. No, ಪರವಾಗಿಲ್ಲ sir. Give it. No, end of the board, sir. No, sir. Yes. What is the urgency, sir? What document, sir? No. All right. Monday. Give pending matters ಕೊಟ್ಬಿಡಿ. Don't stand there. Yes. Give pending matters. No date on pending matters, please give. Yes. ಬೇಡವಾ, ಕೊಡಲ್ವಾ? Pending matter ತಾನೆ. Fresh ಆದ್ರೆ Monday. Fresh ಆದ್ರೆ Monday. Yes.
With my lords, kindly. NHAI, my lords, has damaged a stormwater nala. My lords, the water is flooding into my
2:30.
property. My lords, tomorrow, my lords.
ವಾಟರ್ ಫ್ಲಡ್ ಆಗೋಗ್ಬಿಡ್ಲಿ, ಪರವಾಗಿಲ್ಲ. ಹಂಗಾರೆ ಸುಳ್ಳದು.
ಇಲ್ಲ.
No flood, nothing. Monday. Yes.
My lords, ಆಯ್ತು my lords.
If water is flooding into your house and you have no urgency till tomorrow, Monday. ಸುಮ್ಮನೆ ಏನೇನೋ ಹೇಳ್ಬಾರ್ದು.
ಇಲ್ಲ, it's a agricultural land.
ಪರವಾಗಿಲ್ಲ, Monday.
My lords, in the fresh matter, my lords.
ಅಂದ್ರೆ ಗಿಡ ಚೆನ್ನಾಗಿ ಬೆಳೀತು. Water is flooding. Yes,
My lords,
next.
in the fresh matter, the trial court is proceeding to commit the case, my lords.
2:30.
Extreme urgency, my lord. E-sale is issued.
ಸೇಲಾ?
Notice.
ಯಾವತ್ತು ಸೇಲ್?
Fourth, man.
Tomorrow.
Please. 2:30, my lord.
Tomorrow ಬೇಡ, 2:30ಗೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ನಾಳೆ ಕಮ್ಮಿ ಮಾಡಿ.
2:30, my lord.
Why?
No petition is pending for the atrocity case, my lord.
So
Court said that director of the enforcement has issued the notice
to
come and before ನೆನ್ನೆ ಇತ್ತು ಅದರಲ್ಲಿ. ಮತ್ತೆ ತಿರ್ಗಾ ನಾಳೆ ಹಾಕೊಂಡು ಬಂದು ಅಪಿಯರ್ ಆಗಿ ಅಂತ ಹೇಳಿದೆ ಇಶ್ಯೂ.
2:30. Friday, Monday. Pending? No, Monday. Stay ilva.
Civil dispute.
Parole.
Civil dispute. More than 100 people came before the producer. That too, my lords, in the presence of
Fresh pending.
Fresh, my lords.
Monday.
Senior citizens are involved, my lords. Now,
Monday, sir.
please.
Yes.
In this case, my lord, I have responded. Same, my lord. Respect, my lord. I have filed it.
2020.
Sir. Yes.
Send out tomorrow, my lord.
ಯಾವುದು ಸರ್?
ಈ ಬ್ಯಾಂಕ್ ಮ್ಯಾಟರ್ ಸಮಯದಲ್ಲಿ ನಾನು ಬಿಡ್ಡರ್ 20% ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀನಿ. ಪಿಟಿಷನರ್ ಬಾರರ್ ಬಂದು ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್. ಮ್ಯಾಟರ್ ಅರ್ಜೆಂಟ್.
ಸೊ ವಾಟ್? ಬಾರೋರೆ ತೊಂದರೆ ಇಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ, ನಾನು ಬಿಡ್ಡರ್
ವಾಪಸ್ ತಗೊಳ್ಳಿ 20%.
ಅಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಇಲ್ಲಿ ಕೋರ್ಟ್ ಸ್ಟೇ ಇದೆ ಸರ್. ಬ್ಯಾಂಕ್
ತೊಂದರೆ ಇಲ್ಲ, ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. $2:30. Yes. Monday. So what? Monday. Interim model gold ವಾಪಸ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಾ? Interim model gold ವಾಪಸ್ ಕೊಡಕ್ಕೆ ಹೇಳ್ತೀನಿ. No, give it. Monday. Yes. ಮುತ್ತೂಟ ಏನಿದು? ಎಲ್ಲ ಒಂದೇ. Yes, next. Monday. Yes. No 2:30. In that, why will it become infructuous? For what? Seizing of the gold. Investigating officer. PF ಮಾಡಿರ್ತಾರೆ, ವಾಪಸ್ ಕೊಡ್ಸೋಣ ಬಿಡಿ. Yes, next. No, Monday. Yes. We have for the respondent. Sale certificate issue ಆಗಿ ನಿಮ್ ಇಶ್ಯೂ ಆಗಿದ್ರೆ ಏನೀಗ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ. Yes. It's all right, give it. Yes. ನಾಳೆ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ. No, tomorrow, sir. Give it. Yes. Fresh ಆದ್ರೆ Monday.
Can't do it here.
Friday. Fridays.
Do both.
When is the sale? You have the respondent, my Friday code. Friday,
What?
pending or fresh? Give it Monday. Monday, Monday, madam. Monday, no time. Yes. Parole, ಏನಾಗಲ್ಲ. Yes, next. Why? ಓಯೋ ಅಷ್ಟೇ ತಾನೆ, ಮಂಡೇ ಕೊಡಿ, ಏನಾಗಲ್ಲ. ಏನು ಓವರ್ ನೈಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮುಗ್ದೋಗಲ್ಲ, ಕೊಡಿ. Getting the iron idle, all right. Ask the police to give protection. Tomorrow, yes. No, tomorrow, sir. ಆಯ್ತು, tomorrow.
Try to go and give me this thing here. I think better get out.
Friday. Monday, yes. Monday. ಆಯ್ತು, 2:30ಗೆ ತಗೊಳ್ಳಿ. ಎಸ್. ಡೇಟ್ ಇತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಕೊಡ್ತೀವಿ ಮತ್ತೆ. ಅದು ಮೇಡಮ್, ಅದು ಫ್ರೈಡೆ ಹಾಕಿ. 10 lakhs ಡಿಮಾಂಡ್.
ಮಿಲ್ಕ್ ಯೂನಿಯನ್ ಮ್ಯಾಟರ್ ಮೇಲೆ
ಮಿಲ್ಕ್ ಯೂನಿಯನ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಈಗ?
ಅದರಲ್ಲಿ ಟೆಂಡರ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಾರೆ. ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ಇದೆ ಮೇಡಮ್. ಟುಮಾರೋ ಡೇ
ಫ್ರೆಶ್ ಮಂಡೇಗೆ ಹಾಕೋಣ. ಫ್ರೆಶ್ ಮ್ಯಾಮ್ ಮಂಡೇ. ಫ್ರೆಶ್ ಮಂಡೇ. It will come on Friday. Yes. Being spoken to ಏನು ಮೆಮೊ ಮಾಡಬೇಡಿ, ಅವ್ರು ಬರ್ಲಿ, ಅದು ಹಾಕ್ಲಿ ಬಿಡಿ.
Yesterday there was a submission that account is closed. Account closed ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, KV ಲೊಕೇಶನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿರೋದು.
ಆಯ್ತು.
ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಸ್ವಾಮಿ. ಏನು ನಾವು ಏನು ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಚೆಕ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಆಯ್ತು, ತೊಂದರೆ ಇಲ್ಲ. ಮಂಡೇ
ನೋಡಿ, it will be
ನಾಳೆಗೆ ಹಾಕಿ ಅಷ್ಟೇ.
ನಾಳೆಗೆ ಇದು ಅವ್ರಿಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
ಆಯ್ತು,
ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡಿ.
ನಾಳೆಗೆ ಹಾಕಿ.
Today 2:30.
No, 2:30 ನಾಳೆ. Next, call the case.
Malad, one submission can I make, Malad?
Yes, sir.
So serial number 127, I'm sorry to be making this submission. Adu passport release this ಸ್ವಲ್ಪ urgency to your lordships. I've heard
120, yeah.
127. Both respondents have no objection for that. But one order from your lordship is there, Malad, because nobody is even contesting. And the other day even Shanti Bhushan also came in. 127.
We'll take it by 1:15 or 1:30.
Obliged, Malad. Highly obliged, Malad.
Humble request. Serial number 118 is pertaining to payment of stamp duty on the and penalty on the sale agreement. Matter the set down.
ಏನ್ ಬೇಕೀಗ ನಿಮ್ಗೆ?
On 7/4 the case.
ಈಗ ಏನ್ ಬೇಕು?
I filed an application for stay of the further proceedings in the trial court. Serial number 118.
So
the
adjournment ಬೇಕಾ?
ಇಲ್ಲ. The matter I've sought for stay of the proceedings because the court is set down the matter for.
ಆಯ್ತು, 118 ಬಂದಾಗ ತಗೊಳ್ಳೋಣ.
ಅಲ್ಲ, this is in B group.
So what?
If it may reach, or today I am having some inconvenience in the afternoon.
No, I am fully convenient. Don't worry. Yes.
All right, maybe.
No, we'll reach ಆಗದಿದ್ದಾಗ ನೋಡೋಣ. What sort of submissions are these? Yes, next.
Fresh matter, seal number 1.
Why did you move this?
Malad, the matter against the co-accused has been quashed.
So?
Malad, page number 62, Malad.
So ಏನ್ urgency ಇತ್ತು?
Malad.
ಏನ್ urgency? 7980 KP Act. Enter ಮಾಡಿಲ್ವಾ?
No, Malad, the fresh matter.
ಸುಮ್ನೆ urgency in project move ಮಾಡ್ತೀರಾ? There is no urgency in this at all. 2022 crime.
Hold on.
ಮತ್ತೆ this is why there is a problem. Urgency in project ಮಾಡಿದಾಗ ಪ್ರಾಬ್ಲಮ್ ಆಗ. Page 67 covered and close my. 62, sorry. 62. Petitioner is before this court seeking the following prayer. This court, the co-accused, has quashed the proceedings in criminal petition, page 62 alide. The court, while quashing the proceedings, has held as follows. In the light of the proceedings against the co-accused being quashed, the benefit would inure to the said benefit would inure to the petitioner as well. Same order, no, court part. For the aforesaid reason, same order. Next.
Number 2,
Lord, I appeal for the petitioner.
Post and preliminary hearing B group, interim order subsisting will continue to the next date of hearing. Next.
Lord,
3,
submitting.
Yen bekar haki. Next.
3,
Lord, I appeal for the respondent's counsel.
Yes, sir.
Interim order is complaint, my lord.
Hmm.
I have challenged the possession notice.
7/8/2023 is the interim order granted.
Yes,
When did you comply?
memo of complaints.
When did you dates matra heli, don't take me to the pages. When did you comply?
19/8/2023.
19/8?
2023.
Like
23 li 70 lakhs, 7/8 li 70 lakhs rupees, 19/8 70 lakhs rupees. Memo of complaints I have submitted.
ಆಯ್ತು. Again, what is the problem now?
ಇಲ್ಲ, ಇಲ್ಲಿ 13/4 I already challenged before the DRT. It is pending adjudication.
All right,
This is section 14.
all
They
right.
want to take the physical position. For that, interim order has been granted.
13/4 ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಲ್ಲ?
ಮಾಡಿದ್ದೀನಿ.
ಅಲ್ಲಿ ಕೇಳಿ ಅದನ್ನೆಲ್ಲ.
ಇದು section 14 ಇದು.
ಈಗ ಆರ್ಡರ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲಿ interim order ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ.
ಟಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಅವ್ರು ಹಾಕೋಬೇಕು.
I make a submission.
So who are you?
I appeal for the respondent bank.
All right.
Counsel. The order was by virtue of an order passed by this honorable court, we redelivered the possession to them.
Correct.
Now, for the purpose of readjustment of the equities, because they filed the 13/4 petition way back in 2022, and it is still pending and not an inch
Where?
in progress before the DRT.
Right.
So now-
Move the DRT.
So far as the whole issue came up when the matter was listed last time, they came out with an application for memo for withdrawal. The honorable court did indicate.
Withdraw ಅಲ್ಲ?
ಹೌದು,
ಯಾಕಂದ್ರೆ ಮೆಮೋ ಬಿಟ್ಟು ಇದನ್ನ ಮಾಡೋದಕ್ಕೆ ಸೊ ದಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ 13/4 ಅಲ್ಲಿ. ಸೊ ದಿಸ್ ವಿಲ್ ಹ್ಯಾವ್ ದ ಬೇರಿಂಗ್ಸ್ ಆನ್ ದಿಸ್ ಅಂತ ನಾನು ಬಂದಿದ್ದೆ. ಮೆಮೋ
ಈಗ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇಲ್ವಾ ಈಗ?
ನಾನು ಐ ಆಮ್ ರೆಡಿ ಟು ವಿತ್ಡ್ರಾ.
Then what?
My lord, the difficulty is that they may have to be put on further terms. The honorable court did indicate that.
Take further terms before the DRT. Matter is pending before the DRT.
Since 3 years.
That is up to you to move the DRT.
My lord, with 8 crores outstanding.
You move the DRT, sir. I will close this petition now. Yes.
With a little, what I would say, the fixing the time frame for.
No, dear. You move the DRT. The petitioner is before this court seeking the following prayer. This coordinate benches of this court from time to time have passed certain orders. On 12/6/2023, the following order. And on 7/8/2023, the following order. The learned counsel for the petitioner submits that the interim orders granted. The condition stipulated in the interim order for deposit of 2 crore 10 lakhs has been complied with. The learned senior counsel V.V. Shankar Narayan Rao, representing the bank, submits that representing the finance submits that the matter is pending before the DRT where the challenge is to the notice issued under subsection 4 of section 13 of the SARFAESI Act 2002, and the matter is not being moved by the petitioner before the said court on the strength of the pending matter before this court. The learned counsel M.A. Rajendra would submit that he would wish to withdraw the petition in the light of the compliance with the interim order, as also the fact that the entire issue is pending at large before the DRT in a proceeding instituted by him challenging the order under subsection 4 of section 13 of the SARFAESI by the bank. In that light, I deem it appropriate to permit the petitioner to withdraw the petition and urge all the contentions before the DRT in the pending essay.
Diary number 2086, page number 5 mention ಮಾಡಿದ
In the in diary number 2086 of
22.
2022. The learned counsel for the learned senior counsel submits that the matter is not being taken up by the DRT. It is for the petition. It is for the bank to move such application before the DRT and seek expeditious disposal of the
Out in that matter, it is not my submission that-
expeditious disposal in the matter. If the respondent is not served, appropriate steps be taken by the bank itself to move the DRT. With the aforesaid observations, the petition stands
But
disposed.
8 crores is the outstanding.
ಆಯ್ತು ಅಲ್ಲಿ ಮಾಡಿ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ.
If the matter is heard on merits, your lordship, within a 1 minute, my writ petition will be allowed because this order passed by the magistrate. It is not in accordance with section 14 of the act.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Only the petition is entitled to take physical possession under section 14 of the.
Petitioner.
Petitioner. That is the order.
No, that's finding is to the contrary, my lord and friend.
No,
That's
it is
not
there.
right.
I may permit to
With the
read the
help of
order.
Police, with the help of the police, it has been taken and this honorable court directed.
Bank will never be permitted to take possession of
This
the property.
honorable court did direct me to redeliver the possession.
ನೀವು ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ?
That's what mistake.
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೇವೆ ನಾವೀಗ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಮೇಲೆ
ಇವಾಗ ದುಡ್ಡು 2 ಕೋಟಿ 10 ಲಕ್ಷ ಕೊಟ್ಟಿದಾರಲ್ಲ?
8 ಕೋಟಿ 10 ಲಕ್ಷ ಬಾಕಿ ಇದೆ.
ಬಾಕಿ ಇರೋದ ಟೋಟಲ್ ಅಮೌಂಟ್.
Total 8 ಕೋಟಿ 10 ಲಕ್ಷ.
5 crores
As on
86
today,
lakhs ಇದೆ.
My lord will appreciate the difficulty which has arisen is that having taken an interim order from, I mean, this honorable court after due consideration.
Move the DRT.
Yes.
I don't understand. The bank is not wanting to move the DRT. Move the DRT.
Till then, at least some additional readjustment of equities, my lords may consider, my lord. I'm not saying that when the submissions were made, this honorable court did consider. Did
Sir,
appreciate
1
my
minute.
point.
If it is a case where not a penny is paid pursuant to the interim order, we will vacate the interim order straight away. 2 crores 10 lakhs is paid pursuant to the interim order. So you move the DRT. Yes.
Highly obliged.
Aforesaid observation, petition stands disposed. Yes, next.
Hearing for petitioner, my lordship.
Hmm.
The interim orders granted by this court may be protected at least 3 weeks of court.
ಹೆಂಗೆ ಏನಕ್ಕೆ? For what ಕಾರಣ?
Stay there.
For what reason?
Already stay. 34
ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ ನೀವು? Yes.
I got a shock when this.
No, don't be in shock, sir. Sometimes we grant such, I'll grant now.
No.
So shock will be vindicated. Yes.
We'll leave it at that. We'll leave it at that.
Yes.
Children are there.
It is not indicative shock, it will become vindicative shock. Yes. Yes.
I'm obliged for
Yes.
whatever you got.
Yes.
Actually, there is
Yes.
no criminal antecedents, my lordship, except the 2 check bounce cases, my lord.
Check bounce case, ಬೇರೆ ಏನಿಲ್ವಾ?
Where this one, except this, there is
Ah.
none.
ಅಷ್ಟೇನಾ? ಏನ್ ಲುಕೌಟ್ ಸರ್ಕ್ಯುಲರ್?
Yes, my lord.
ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ಗೆ?
Here, yes, there's a 420 case.
Only one case is pending, my lordship, which is this one.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ನೀವೀಗ?
Dubai, my lordship.
ದುಬೈ.
Is treated to the tune of almost 85 lakhs.
He is having
So
a business in
you
Dubai,
file,
my
you
lordship.
file your travel itinerary with affidavit when do you return back and everything. ಎಲ್ಲಿ?
If my lordship permits, like we will take permission from the court and we will travel, my lordship.
Move ಮಾಡಿ ಹಾಕಿ. The petitioner shall place on record the travel itinerary and an affidavit of return from the United Arab Emirates where he is wanting to travel, which has been stalled due to the lookout circular hanging on his head. List the matter on Monday. Yes, Latif. ಯಾವತ್ತು ಹೋಗ್ಬೇಕು ದುಬೈಗೆ?
Lord, he's having a business plot if it is.
No, affidavit ಹಾಕಿ see, LOC quash ಮಾಡಕ್ಕೆ we'll have to hear the matter. We'll keep it in suspension because it's only 2 cases or whatever is pending. But you have cheated someone with 85 lakhs.
Charge sheet has been filed and it's stayed now.
Then you will run away from the trial.
Allah, we'll take a permission from the trial court, Lord.
Then you take it. I will,
If it is LOC
I will
has
pass
been
an order.
recalled.
Who has recalled?
Lord, if it is.
No. I will not recall the LOC. ಅದಕ್ಕೆ you file an affidavit here. We'll permit you travel, we'll give you travel permission.
Please,
We'll take it on Friday.
please.
Affidavit haki. Yes. Next.
5.
My lord, on the last day, your lordship had asked me to find out whether notice had been issued before a survey was conducted.
Survey, yes.
No notice is issued.
Then
Then redo the survey, my lord.
Redo the survey.
My lords, in the
If it's
meantime,
a
I have
date-
filed an application
I'll
for
keep this pending, sir. Let the survey happen.
Date and
Yes,
time.
my lords,
This
in the
court-
meantime, let them not put up any construction on my side.
This court on 25/3/2025 had passed the following order. The learned HCGP on instructions and verification of the records would submit that no notice was issued to the petitioner at the time of conduct of survey. Therefore, it is a unilateral survey and the report thereon. The survey in the aforesaid circumstance will have to be redone in the presence of the petitioner. Therefore, the joint survey be conducted, next Friday? Joint survey be conducted on 10th of April 2025 at 11 a.m.
Seems to be a holiday.
11th of April 2025 at 11 a.m. No separate notice need be issued to the petitioner for his presence at the time of survey. The survey shall be conducted, the report of survey shall be placed before this court on the 16th of April, list on 16th.
11 a.m.
Till,
11 a.m.
sorry?
11 a.m.
11 a.m. on 11 a.m. Yes.
Till
List
then,
the
let
matter
them
on
not put up
16th. The
construction.
respondents are restrained from putting up any construction in the property said to be belonging to the petitioner till the next date. Next.
Lord, we'll place the
Petitioner applied
census,
for-
Lord, on next Monday or Tuesday, my Lord, we'll place the census.
List the matter on 16th. Yes, next. In preliminary hearing.
Great.
Next.
7.
Yes, sir.
This is a case covered by the Supreme Court judgment.
Covered by what, sir?
But this.
Pronit, sir.
Yeah. Really, they have taken the Structural Securitization Act, where it is an MSME unit, a notification which has not been followed, and it has been upheld by the Supreme Court also. That the committee of the creditor, those committee to be constituted before proceeding any recovery actions under the Surface Act. That's the position of Malone. That procedure is not.
Which paragraph in Pronits?
Supreme Court judgment.
ಅದನ್ನೇ Pronits Supreme Court judgment ಯಾವ paragraph ಅದರಲ್ಲಿ?
The impure, the 18 Malone.
Para 18.
18. In view of the matter, it has been considered. In view of the matter, we are of the opinion that the findings accorded by the High Court in the impugned order, that the banks are not obliged to adapt the restructuring process on its own, or that the framework contained in the notification dated 29/5/2015, as revised from time to time, could not be said to be mandatory in nature. They are highly erroneous and cannot be countenanced. The instructions about directions issued by the central government under Section 9 of the MSME Act and by the RBI under Section 21 and Section 35A has statutory force and are binding to all the banking companies. This is the position, my lord.
You are an MSME, yeah?
Yes. I have furnished at Annex 8 of a registration certificate, and there is a specific procedure for closure of such units also as contemplated in Section 25 of the MSME Act.
All right. What is the due, amount in due?
It is about 15 crores, 50 lakhs.
15?
Now it is
15 crores. It was sanctioned in the year 22 only. In the year 2022 for MSME purposes. It was declared as NPA in June 2023. And without following this procedure, where we are not running away, we just wanted to do the business. Without following this procedure of constitutional rehabilitation framework when it has been provided, that has not been followed. That's my case. Where if they have not given an opportunity for revival of the unit or restructuring. So the notification is itself just is mandatory in nature for the bank, which they should have complied that. Without that, they are not supposed to initiate the recovery proceedings and Surface Act, for which I have asked for.
Ashtana? Yes, madam.
My lords, we cannot deny the mandatory nature of the notification, my lords, but we cannot follow it for the reason that their unit is closed in 2023.
Whose unit?
I will place on record their own letter issued to us.
The unit is closed in?
Yes, 2023 June, my lords.
Good.
So the framework, my lords, does not apply to them, neither the Pronits judgment applies to them.
No,
because we
the
cannot.
unit should be functioning at this.
Please,
If
I may kindly take my lords
ಆಯ್ತಲ್ಲ,
to,
ವಾಪಸ್ ಬರ್ತೀವಿ.
I'll take my lords to page number 36 of the petition, my lords. They produce a notification.
36.
Annexure D.
Yes.
My lords, here under the scheme of this notification, my lords, a two-tier system is contemplated for a recovery of the amounts pertaining to MSME units before categorizing it as NPA. My lords may kindly see the first clause. Identification of incipient stress.
Yes.
My lords, first, the banks have to identify the incipient stress by creating 3 categories of, my lords, the accounts.
All
It's
right.
called a special mention account, my lords.
All right.
That is SMA 0, SMA 1 and SMA 2.
Hmm.
Well, it's SMA 0, my lords, it says that if this overdue is more than 30 days, then that category falls into that category. Likewise, my lords, if it is more than 2 months and 3 months, the next 2 categories. After identifying, my lords, what comes into place, clause 5 of the next page, my lords, page 38. Clause 5.
Corrective action.
Corrective action, my lords. Here, subclause 4 may kindly be seen. Clause 1, subclause 4(1) says first method is, my lords, rectification,
Yes.
whereas, my lords, a specific commitment has to be given by the borrower that he will pay in a certain time.
All right.
If that is not an option for them, then the second is restructuring.
All right.
Even if that is not possible, my lords, both the 2 methods fails, the third one comes into play, that is a recovery.
All right.
So recovery, I'll read out, my lords.
Yes.
Once the first 2 options at A and B above are seen as not feasible, due recovery process may be resorted to. The committee may decide the best recovery process to be followed among the various legal and other recovery options available with a view to optimizing the efforts and results. So we have issued them the notice under surface E only after ascertaining that the unit is closed, my lords. We cannot, my lords, take these methods to resolve the,
So
my lords.
there cannot be rectification and restructuring of a closed unit is what you say.
Please.
All right.
And pronix doesn't cover that. It only, the petitioners are subsisting MSME units in pronix.
Pronix.
Please,
That's all? That's all.
please.
Yes,
Right,
sir.
sir. Closure of the unit is provided under section 25 of the MSC Act. Here, the business activity alone has been just, is not able to be carried on. How to exit from the scheme? How to face that
So it
facilitates.
is, your unit is closed is an admitted fact.
It is, so business has not been carried out.
No, that's all right.
Well,
You-
that 3.6, page number 14 of their inspection report, Malak, in their objections, they would say
Yes.
it is.
What is the amount in due totally?
As on today, it's 18.050, my lords.
18.5 crores.
18.56 crores.
18.56 crores.
The
ಏನ್ ತಗೊಂಡ್ಮೇಲೆ ಏನು ಕಟ್ಟೇ ಇಲ್ವಾ?
ಏನು ಕಟ್ಟಿಲ್ಲ. ಬರೀ before, after NPA was done, they, I think 95 lakhs was.
They have paid 79 lakhs.
79
After
lakhs
the account was declared as NPA, also it was paid. And they have submitted the proposal for sale of the property itself, which has been taken as a collateral security.
All right.
And that was the position.
Yes.
Where the
Really?
account was regularized till 36/2003, my lord, as per their own.
No, no, that's all right. Up to July 2023, it was regular. Yes.
36.
Now
So-
you are referring to statement of objections.
Yeah,
What?
so page number 14, where the account was regular till 36/23. That is the observation in their inspection.
That's all right. What is your suggestion?
My suggestion is that if this resolution framework had been adopted at that time as contemplated under the act, the situation would not have come. And therefore, that is where the framework need to be possessed for this kind of restructuring or for providing the
No,
facility.
if it's a closed unit, where is the question
Not
of
closed unit,
restructuring?
my lord. The business, the unit is existing. It is not that unit is closed. The business was unable to be carried out for the said reason
What
that
does
because
that
of the
mean?
process.
What does that mean?
The machineries, everything was.
Building ಇದೆ ಒಳಗಡೆ ಏನ್ ನಡೀತಾ ಇಲ್ಲ.
Machineries, everything is there. Machinery.
ಇಲ್ಲ ಆಯ್ತು, business ನಡೀತಾ, bank wants business ನಡೀತಾ ಇಲ್ಲ ಅಂದ್ರೆ it's closed.
Alla bank, what is happening? Business machineries were there.
ಇಲ್ಲ,
And it
building
was
ಇದೆ,
never
unit
disposed of.
ನಡೀತಾ.
My lord, is it not the duty of the bank to have come to the rescue?
Is
At
it
that
not the
time, where
it
as
is
per
not
the
your duty to
notification
repay the
inspection
amount
government
once
law.
you have taken? Is
Minister,
it not your duty to repay the amount? 18 ಕೋಟಿ ಬಾಕಿ ಇದೆ.
Even I have given my letter. My letter, your lordship may.
Your
produce.
letter is here. Yes.
The lordship may produce annex G, I have produced that, where I have submitted even for settlement of the proposal, even for the enabling sale of the unit. But this was the time where I needed the funds, which was not given as per the resolution framework that was
So for the
mandatory
last,
in
the
nature.
petition is pending since 24. No, it is unconditional interim order,
Yes, my lord.
not a rupees paid.
Because he suppressed the fact that it is closed and he said he took
Well,
the
just given
shelter
that
under
never-
the Proceedings
never I
judgment,
said,
my lord.
I'm admitting that my submission to your lordship is this.
Alla, building ಇದೆ, business
Allah,
ನಡೀತಾ
this resolution should have been adopted. Framework should it not have been adopted, my lord? Then
Correct.
what is the meaning for helping
Bank
an
should come
MSME
forward,
unit?
bank should come forward, help you in
It is
every case.
as expected under the notification. I am not suggesting anything. Even the
But
Supreme
even
Court has
under the
said,
notification,
the bank on its own, they should have just provided, or I was myself, it is not running away from the business. I have made that, I am trying to just resolve. I am trying to restructure. I am trying to just have that the business develop. In that view of the matter, and just before this, it should have been adopted as per the
Alright.
resolution. That's a mandatory requirement, which the bank has failed to do.
Alright, heard reserved, yes.
great, my lord.
Interim order subsisting will continue till the disposal of the petition. Reserved. Next.
Challenge the order of the Judiciary Tribunal. Sought for a permission to cross-examine the witness of the applicant banker. And that application came to be.
Yes, sir, we will allow this.
My lord, we have filed our objections. My lord, in addition to that, my lord, two more submissions I would like to make before my lord.
Yes, sir.
First and foremost, my lord, 2021, when I complete my evidence, my lord, that time itself, my lord, they would have filed an application before the DRT or before this
Is
honorable.
a division bench ತಾನೆ?
Difficulty is this, my lord. The honorable division bench said, you carry on with the both matter before civil court as well as DRT. My petition pending for the DRT 2015 and subsequently that, my lord, they filed a matter for the civil. Now, my lord, in civil court, my lord, day-to-day basis, my lord, the matter is going on. Even my first instance itself, my lord, my cross-examination taken as nil. Now, lord, after one undertaking from the learned counsel
ಇಲ್ಲಿ
saying that.
issue ಇರೋದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೊಟ್ಟಿಲ್ದಿರ ತಪ್ಪ ಸರಿನಾ ಅಷ್ಟೇ. You are enlarging the scope of the petition from the first day of argument.
Lord, that being the case, my two
Then
more
we will have
submissions.
to mulct you with costs if this is
My
the
lord,
case.
my two more submission may be recorded. In fact, my lord, I filed my detailed objection in this matter.
No problem. Yes,
My lord,
objections ಅಲ್ದೇನೆ submission ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ ಅದ್ರಲ್ಲೇ.
ಸರಿ.
The thing is, my lord, the order I said before this honorable court, my lord, passed by the DRT pursuant to interlocutory application filed by the my lord petitioner.
Correct.
There's a remedy under section 18. In earlier, my lord, all the procedure, my lord, which he adopted the same, my lord, it went up to my lord.
appeal ಹೋಗ್ಬೇಕು ಅಂತ.
Section 18, section 20. That is, my lord, my first and foremost submission before this honorable court. My lord, it can't be, my lord, straight away, my lord. That's one. In respect of second submission, my lord, my second limb of submission, my lord, 2021, I completed my applicant evidence. They would have filed that time itself, my lord, the application before the my lord, DRT or before this honorable court. No, my lord, after lapse of my lord, 3 years or 4 years, my lord, after suffering the order from the division bench, my lord, he can't come with the my lord, filing an application before the DRT. That's not correct. My lord, my third submission before this honorable court. The honorable Supreme Court in the case of my lord, I just point out. Paragraph 23 and 24, my lord, that page number. Paragraph 22, page number 14. In the case of my lord, Union of India versus my lord, Delhi Paris. At the outset, you find that Rule 12 is not happily worded. The reason for establishing banking tribunals being expedited disposal of the claims by the bank, the Parliament thought it proper only to require the principle of natural justice to be guiding factor for the tribunals in deciding the applications, as is evident from section 22 of the Act, while the tribunal has no doubt been given to power of summoning the enforcing the attendance of any witnesses and examining him on oath, but the Act does not contain any provisions which it makes mandatory for which witness examine if such witness could be produced. Rule 12(6) has to be read harmoniously with the other provisions of the Act and the rules. As we already noticed, Rule 12(7) gives the tribunal the power to act upon the affidavit of the applicant where the defendant denies the liability to pay claim. Rule 12(6) perhaps would read as follows: the tribunal may at any time to the sufficient reason order any particular fact or facts may be proved by affidavit on such condition as the tribunal thinks reasonable. The tribunal may at any time for sufficient reason order that affidavit of the witness may read at the hearing on such conditions that tribunal thinks reasonable. In other words, the tribunal has power to require any particular fact to be proved by affidavit, or it may be order the affidavit of any witness may be read at the hearing. While passing such order, it must record sufficient reasons for the same. The provision Rule 12(6) would certainly apply only where the tribunal chooses to issue direction on its own for any particular fact to be proved by affidavit or the affidavit of a witness being read at the hearing, the said proviso refers to the desire of the applicant or defendant for the production of witness for cross-examination. In this setting, which the said proviso occurs, it would appear to us that once the parties have filed the affidavits in support of their respective cases, it is only thereafter that desire for witnesses to be cross-examined can be legitimately arises. It is all the time if it is appears the tribunal that such a witness can be produced and necessary to do so, and there is no desire to prolong the case, that it shall require the witness to be present for the cross-examination, and in the event he is not appearing, the affidavit shall not be taken into evidence. When High Court and Supreme Court in exercise of their jurisdiction, Article 226 and 32 can decide question of fact well as law merely on the basis of documents and affidavits filed before it ordinarily, there should be no reason as to why the tribunal likewise should not be able to decide the case merely on the basis of documents and affidavits before it. It is common knowledge that hardly any transaction with a bank would be oral or without proper documentation, whether in the form of letters of formal agreement. In the event bona fide seed for the oral examination of witness should be rarely arised, there has to be very good reason to hold that affidavits in such case would not be sufficient. The manner in the dispute is to be adjudicated upon the decided in the procedural laws which are enacted from the time to time. It is because of the enactment of the civil procedure that normally all disputes between the parties in civil nature would adjudicate upon the civil courts. There is no absolute right in anyone to demand that dispute is.
All right. ಎಲ್ಲಿ ಓದ್ತಾನೆ ಇದ್ದೀರಾ?
22 to 24.
ಅಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು.
ಹೌದು. My respectful submission is.
Yes, sir.
My lord, my submission is that, my lord, there was already an order of this honorable court.
You file your list of dates and events.
In fact, I placed.
ನೀವು ಮಾಡಿದ್ದೀರಾ? ನಿಮ್ದು ಬೇಡವಾ?
I will file it.
Do it fast. List day after tomorrow.
18 also, my lord, in a similar circumstances.
Serial number 18.
18.
18 ಅಂದ್ರೆ 18 ಪರವಾಗಿಲ್ಲ, ಅದೇ ಕೇಳಿದ್ದು ನಾನು. ಹೇಳಿ.
23.
Serial number 23.
23 ಅಂದ್ರೆ different.
23.
Yes.
There are 5 applications that DRT passed an order on the very.
Serial number 23.
23.
Tag this 8 and 23. List them both on Friday.
Great.
Yes.
Grateful.
Astrali Madhukar.
Yes, sir.
Tomorrow you file everything.
I will serve the copy.
Serve a copy and.
Grateful.
Next.
9.
Pray for petitioner. I'm challenging the order
ಏನು ಸೋಮಣ್ಣ
of
ಇದು?
detention issued by the FRR, my lord.
Detention.
Detention, my lord.
Oh, this is Nigerian.
Nigerian national, my lord.
ನೀವಿದ್ದೀರಾ?
Yes, my lord. There was earlier, he was arrested with respect of a NDPS case, and then he was enlarged on bail, my lord, in the year 2016. There was a certain condition was imposed that he should not involve with the similar type of an offense. Then, my lord, he was involved in the similar type of an offense. Then by that time, my lord, we have established a center at Sondekoppa by virtue of a notification which has been issued. That is Babul Khan judgment, my lord. We have whoever have committed these type of offense, we have to retain them in a center. And accordingly, he has been in that particular
Detained in
center.
that center now. Since
And-
when?
My lord, from the year 2021, he has 23, he has been in the center.
2 years has been in that center.
Yes.
When was the next crime committed by him pursuant to the first bail order?
My lord, 2018, my lord.
18.
2018, my lord.
ಆಮೇಲೆ?
My lord, subsequent to that, they issued an order of detention in the year 2021, my lord.
Ah.
In 2022, I was released from the detention center, my lord. The order issued by the FRO. Again, in 2023, they have issued another order of detention and they have sent
Why?
me to detention.
Why?
Because there is no reason given in
ಯಾಕೆ
the.
you did not get yourself involved in any NDPS case
No, my
again?
lord. The 2018 was the last time the FIR got registered, my lord. The last case registered against me was in
Which
the
is
year
the
2018.
which is the last crime registered?
The last crime registered is the 2018.
Then how are you detaining him?
My lord, he was enlarged to enable him to appear before the court, my lord.
Correct.
He has appeared before the court.
Correct.
Later, we also find that, my lord, this particular person is overstaying and whatever the passport details he has provided, all fake. My lord, that was initially, my lord. In
So, ಆಮೇಲೆ?
2000, my lord, in 2013, my lord, he arrived in India on medical visa, my lord. 2015, a case gets registered against him for offences punishable under section 420 and other sections, my lord.
No, so this
Section under the
2015
IT Act, my lord.
Sir, your documents are all fake is what is alleged.
My lord, he's got a valid passport, my lord. He doesn't have a visa, my lord.
Then how did you come into the country?
My lord, he's come to India illegally, my lord. That is not disputed. I have admitted that he's come to India illegally, but he's
ಈಗ
not valid passport. I request my lords to kindly take one document, my
No,
lord.
no, go back.
My lords, because the cases are pending against me, I'm not allowed to
ಯಾವ
go back,
case
my
pending
lord.
ಇದೆ?
The NDPS cases are pending.
My lords,
Both the
ಎಷ್ಟಿದೆ?
cases, 2 cases are pending, my lord. And
At what stage they are?
I need to take the
Unless
instruction.
it is at the stage of evidence, my lords. 2015
Yes, my
case inna nadita ide, my lord. Trial is still going on.
Will direct trial to be completed. Till then be where you are.
My lord,
ಇದರ ಆಚೆ ಹೋದ್ರೆ ಮತ್ತೆ ಇನ್ನೊಂದು ಕೇಸ್ ಮಾಡ್ತೀರಾ.
my lords, illa, my lords. 2018 ಆದ್ಮೇಲೆ cases register ಆಗಿಲ್ಲ, my lords. They had released me from the detention center. Again, they have issued an order of
But
detention.
why did you retain him again in 2023?
My lord, the information what he had provided, I request my lords to kindly take one document, that is Annexure A, that is the application form, my lord, Bureau of Immigration, which the passport details have been provided.
Correct. Passport ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ fake.
Everything is fake. His stay,
Everything
his
ಅನ್ನೋಕೆ
what
ಬರೀ
details, what
passport
he
ಒಂದೇ
has.
ಇದ್ದಿದ್ದು, my lord.
What's your name?
Onahu
Aga. Huh?
Onahu Aga.
Onahu Aga. ಆಗ ಅಷ್ಟೇ, ವಾಪಸ್ ಇಲ್ವೇ ಇಲ್ಲ.
And if my lord, the details of passport, what has been provided in Annexure A, page number 16, compared with the order dated 19/1/2022, that is Annexure G, then we came to know, my lord, this passport itself is fake.
My lords, the previous passport was fake, my lords. The one which is existing now is
Correct.
correct passport, my lords. We got the
And then, my lord,
No,
I-
you have
India is
you have entered India
illegally.
with a fake passport, fake visa, ಎಲ್ಲ fake.
My lords, that is admitted, my lords.
Admitted fake.
Admitted. But now is
So
got
finish
valid
the
passport.
trial and go.
My lords, trial is going on from 2015, my lords. He's not appeared before the court from past 1.5 years, my lords.
ಎಲ್ಲಿ ರಿಹ್ಯಾಬಿಲಿಟೇಷನ್ ಸೆಂಟರ್ ಅಲ್ಲಿ ಇದಾರಾ?
yes,
ಇರ್ಲಿ ಬಿಡಿ, ಆರಾಮಾಗಿದಿರಲ್ಲ ಅಲ್ಲಿ.
That, my lords, FRRO do not have the power under the act to issue an order of detention, my lords.
That we will consider. Yes.
Because they
Come
do not
legally, if you want to say something, tell.
My lords, I mean, kindly take the Foreigners Act. my lords,
Foreigners
for a
Act
moment.
ಕೊಡಿ ಮೇಡಮ್. What is that, Madhu?
Yes,
No
ma'am.
power, is it?
No, my lord. There is a we are entitled to impose restriction under the section 14 of the FRRO Act, my lord. And by virtue of that, my lord, a notification has been issued.
Now, under section 14, if a person is overstaying with a valid visa, valid passport, proceedings can be initiated and he can be detained, correct? ನಿಮ್ದು ಎಲ್ಲ fake, valid ಏನೂ ಇಲ್ಲ. When nothing is valid, fortunes are,
But under the
you are
act,
in,
my lords,
you are in
FRRO
rehabilitation set.
My lords, only the central government has the power to issue an order of detention under the act, my lords. Under section 3 of the act, section 3.
If a notification is issued by the government of India, that's enough. Where is the
There is
notification?
no
I have produced
notification
along
issued.
with my statement of objection.
3G of that, only central government can
The-
issue order of
Who has
detention.
issued notification?
The notification has been issued by the government of India, my lord.
Yes, sir.
By virtue of that particular order, my lord, I request my lords to kindly take Annexure R1, my lord, page number 9. The officer empowered has been explained in this notification. That is page number 13, my lord. At serial number 3, my lord, FRRO Bangalore, Karnataka is the person who is empowered, my lord. At page number 13.
My lords, they can issue.
All right.
only-
How can you contend all this? Yes.
Thereafter, my lord, the center has been established and we have restricted his movement. His rights have not been taken away. Only his movement has been restricted.
My lords, there has to be a
That's-
difference between restriction and detention. my lords.
And
That's the finest of right that you have taken away. Yes.
My contention is that, my lords, there has to be a difference between restriction of movement and detention.
We'll say, we'll
And-
pass. Stage ಕೊಡಿ, stage of the
I will
proceedings.
provide the state.
And 10 years in the trial ನಡೀತಾ ಇದೆ. Trial ಮುಗಿಸ್ಬಿಟ್ಟು ಜಲ್ದಿ,
Yes, ma'am. Yes,
whatever it is.
The details of those cases and
ಎಲ್ಲ
the
all,
stage of the
the
proceedings.
learned counsel Madhukar Deshpande is directed to place on record the stage of the proceedings against the petitioner, cases pending against him and respective stages in those cases. List the matter on 22nd in preliminary hearing. Yes, next.
Interim order complaint. The respondent bank 20 lakhs complaint. Another 20 lakhs I will deposit within.
ಎಷ್ಟಿದೆ total?
70 million. As of now, not 83 lakh 22,000.
ಈಗ ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ?
20 ಕಟ್ಟಿದ್ದೇನೆ. Interim order complaint ಮಾಡಿದೆ.
After
Another 20 million
depositing 20
deposit
lakhs,
within 4 weeks.
After depositing this interim, pursuant to interim order is deposit 20 lakhs.
ಹಾ.
After deducting that amount presently, as of now, 83 lakhs 22,064 rupees.
Next 25 lakhs ಯಾವಾಗ ಕಟ್ತೀರಾ ಸರ್?
4 weeks.
3 weeks I'll grant you. ಇಲ್ದರೆ we will dismiss
4
this.
weeks.
No, sir. Vacation ಬಂದ್ಬಿಡುತ್ತೆ. Yes. The learned counsel S.K. Acharya, appearing for the petitioner, submits that the order dated 13/8/2024 has been complied with. The learned counsel for the respondent bank admits this said compliance but would submit after the said compliance, the amount, total amount in due is 83 lakhs as on today. And would, as the learned counsel S.K. Acharya submits that if 4 weeks time is granted, 25 lakhs would be deposited to the bank. Therefore, the said deposit be made on or before the 2nd of May 2025. In the event no deposit is made as undertaken by the petitioner, not only the interim order would get vacated, but the petition itself would be dismissed. List on 2nd May, interim order subject to the
Remaining amount
aforesaid.
maybe.
Huh?
Remaining amount may be not
One on the
quarterly.
on 25th March.
Interim
This is
order
the
to
matter on 2nd interim, subject to the aforesaid condition, interim order extension. Next.
11.
I request for a passover, my lord. By the end of the day, I'll file the affidavit. Affidavit of the deputy commissioner has to be filed.
Will the deputy commissioner ಬರಕ್ಕೆ ಹೇಳಿದ್ರೆ correct ಇವ್ರಿಗೆ?
ಇಲ್ಲ ready ಆಗಿದೆ. My person is yesterday because ನಾನು
All
ನಿನ್ನೆ
right.
ಕಳಿಸಿದೆ.
Passover.
Can we have it on Friday, my lord?
All right, Friday.
Still under the weather, my lord.
Jafar was busy last 3 days. Sir. Yes.
ಅದೇ ಹಬ್ಬ ಆಯ್ತಾ, which is why
ಅದಕ್ಕೆ
I'm
ನಾನು
also not
no
saying
problem.
anything.
When?
Friday, my lord.
Friday, yes, list on Friday.
Copy.
Lordship, on the last date, I placed the report of the
Yes.
doctor, wherein the petitioner's father.
ಎಲ್ಲ ಸರಿ ಇದೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. Bomb blast.
In fact, in
19 years.
Bomb blast. I am not going to grant parole in bomb blast cases. It is waging war against the state.
Yes, my lord. Even if I have been convicted also for life imprisonment, I almost have completed 19 years. I am asking with the custody, my lord, to see the ailing father. I am asking with the custody.
Father correct, ಏನ್ ತೊಂದರೆನೇ ಇಲ್ಲ.
report ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೂ
Report ಇದೆ ಇಲ್ಲಿ.
In fact,
Report of inspection. No, Siraj. ಬೇರೆದ್ರಲ್ಲೆಲ್ಲ I'll give. You know that I am strict with bomb blast cases and NDPS. Ashfaq, I will quote Ashfaq and close it if you want. If you want me to pass an order, I will pass an order.
My submission is that because almost it is 19 years, the trail has.
Ashfaq Ali, go to paragraph 15 and 17 where the Supreme Court says that it is not mandatory that parole should be granted.
It is not mandatory.
Balance with societal, these cases, you know.
But on the other hand, it is the duty of the state to conclude the trail. If I have been concluded, the trail has been concluded.
ಯಾವಾಗಿಂದ ಟ್ರಯಲ್ ಆಗಿಲ್ವ?
2008, my lords.
Trial
It has
ಆಗಿಲ್ವ?
not been concluded, my lords. 19 cases are pending, my lords, against me.
ಅಲ್ಲ, you are under trial, is it?
I am convicted in one
You are
case.
convicted, ಮತ್ತೆ?
Convicted in one case, and other cases have not been.
You are convicted in one case of bomb blast?
ಎರಡು case, two
I
cases,
have
and
convicted,
there are
my lord.
pending cases
Even according
also.
to the provision of Karnataka Prison Act, my lords, after 20 years, I am eligible for the premature release. It is almost 19 years.
ಆಯ್ತು, ಇನ್ನೊಂದು ವರ್ಷ ಆಗ್ಲಿ ಬಿಡಿ. ಬಾಂಬ್ ಬ್ಲಾಸ್ಟ್ ನಾನು ಕೊಡಲ್ಲ, ಸಿರಾಜ್.
Yes, my lord. A liberty may be given if any serious condition, then.
No problem. That emergency parole you ask or with custody will try to grant if there is serious illness to your father.
Until
they
inquire, my lords, it will.
We'll see. The petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition, reserving liberty to the petitioner to knock at the doors of this court in the event his father would, in the event any illness would ensue to his father. Yes, with the said.
My report may be also be recorded.
ಅಲ್ಲ, ಇಲ್ಲಿ ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. Petitioner is before this court seeking the following prayer. This court passed an order on 25/3/2025. The learned AGA secured a report from the hands of the respondent police that the father of the petitioner does not suffer from any ailment today, and the ailment that he suffered was in the year 2021. In that light, the learned counsel for the petitioner seeks leave of this court to withdraw the petition, reserving liberty to approach this court in the event his father, in the event any illness would ensue to his father. This liberty petition stands disposed. Yes, next.
13. Kindly pass over.
ಪಾಸ್ ಓವರ್. ಲೋಕೇಶ್ ಇಲ್ಲೇ ಇದ್ದಾರೆ. ಯಾವ್ದೋ ನೆನ್ನೆ ಕೇಸ್ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಏನದು?
ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಕೌಂಟ್, ನಾನು ಕೊಟ್ಬಿಡ್ತೀನಿ. ಕ್ಲೈಂಟ್
ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ನಾಳೆ ಮಾರ್ನಿಂಗ್ ಐ ವಿಲ್ ಸಬ್ಮಿಟ್ ಮಿಲಾಟ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದ ಬ್ಯಾಂಕ್ ಟು ಕೋರ್ಟ್.
ಆಯ್ತು, ಫೈನ್. ಎಸ್, ಇದ್ರಲ್ಲಿ ಏನು?
ಇದ್ರಲ್ಲಿ ದೇ ಹ್ಯಾಡ್ ಟು ಫೈಲ್ ಅಫಿಡವಿಟ್.
ಕ್ಲೈಂಟ್ ಬರ್ತಾ ಇದ್ದಾರೆ.
ಫೈಲ್ ಮಾಡಬೇಕಾಗಿದೆ.
ಪಾಸ್ ಓವರ್. ಎಸ್. ಯಾವುದು?
14.
ರಿಲೀಜಿಯಸ್ ಅಂಡ್ ನೆಕ್ಸ್ಟ್. ಎಸ್. ಏನಿದು?
This is regarding
proposal to declare temple as declared institution.
ಹಾ,
My lord,
ಏನ್ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
our ಹಾಕಿದ್ದಾರೆ.
The
Ah.
recommendation is stayed now. And
ಹೇಳಿ ಅಜಯ್. ಎಸ್.
My lord, on page number annexure B, my lord, is a trust deed. My lord, actually the temple which is my lord belong to Jain community.
All right.
And my lord, it is called as Kelanja Guttu Vishwamurti Devasthana.
All right.
My lord, we have created one trust. And listen, my lord, the trust deed in page number 21. It is dated 27/1/2023. My lord, whether it is exclusive of my lord the public or inclusive, it has to be determined. My lord. Kindly see, my lord.
ಈಗ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ?
ಈಗ ನಾವು ಟ್ರಸ್ಟ್ ಮಾಡಿರೋದಕ್ಕೆ there is a possibility of misappropriation ಅಂತ ಹೇಳಿ they have given complaint to the DC.
Who are you?
But I am the president of the temple managing committee. But their grievance is that before passing the recommendation, they have not been heard in the matter. That is the on sole ground, the recommendation for declaring the institution under section 42, under 43(6), an opportunity has to be provided. That has not been provided.
Let them provide it.
ಅದನ್ನೇ ಮಾಡಿದ್ದಾರೆ. Reconsider ಆಗಿದೆ. And is remanded.
Reconsider ಯಾವಾಗ ಆಗಿದೆ?
Send it back to the DC.
That is my statement of objective, vacating stay I have produced.
On 5/7/24.
And they have been heard?
Now notified, I issued the, produced the notice copy also, they have appeared.
They have appeared.
Appeared. Now the stay order.
ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಈ ಕಚೇರಿಗೆ ಯಥಾರ್ಥವಾಗಿ ಸಲ್ಲಿಸಲು ಕೋರಿದೆ. ಇಲ್ಲಿ ಇವ್ರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟರೆ ಯಾರು?
My vacating stay application, annexure R5 and R4 and R5.
Lord, may I make submission?
Wait, 1 minute.
R4 and R5. ಅವರ ಹೆಸರು serial number 3 ಭರತ್ ಕುಮಾರ್.
ಎಲ್ಲಿದೆ?
Notice,
ಭರತ್ ಕುಮಾರ್. Yes.
ಹೌದು. And R5 also. They have appeared on 23. Therefore, the.
ಈಗ what is the stage of the proceeding there?
Now the stay is there. That
Oh, then we'll reserve liberty and you conclude the proceeding.
No, may I make submission?
ಯಾಕೆ?
No, kindly see the section 42.
ಕೊಡಿ ಮೇಡಮ್ ಆರ್ಸಿ. Yes.
According to which, my lord, may read, my lord, declared institution. State government may, where it is satisfied on report of commissioner under section 43 or otherwise, that any Hindu religious institution, whether or not governed by settled scheme, is being mismanaged.
Declare such institution subject to regulations.
Yes.
All right.
Now, my lord, kindly see, my lord, the complaint. My annexure C, it starts from annexure C.
Page.
My lord, first my lord, I will show this trust deed, my lord.
Where is the complaint, sir?
No,
No,
complaint.
trust deed you forget. You ಮಾಡಿದ್ದೀರಾ? All right.
No, it
Where is the
inclusive
complaint?
of, my lord, all the villages.
Complaint.
My lord, it started from annexure C, my lord.
Page.
Verse 33. Where, my lord, it is in terms of appointing the administrators.
ದೇವಳದ ಆಡಳಿತ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರು, ಕಾರ್ಯದರ್ಶಿ, ಸದಸ್ಯರು, ಸಂಬಂಧ ಸಭ್ಯಗಳು,
ಅದೇ ರೀತಿ ಎಲ್ಲ
ಅಗತ್ಯ ದಾಖಲೆ ಪ್ರತಿಗಳು.
Subsequently, I will give an explanation. Lord, annexure D.
Where is the report of the commissioner?
Yes, my lord. Next, this is submitted by the
That is deputy.
RI, ಪ್ರಥಮ ದರ್ಜೆ ಪರಿವೀಕ್ಷಕರು, to my lord, the ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು.
ಆಯ್ತು. Where is the deputy commissioner's report on mismanagement? ಇಲ್ವಾ?
Annexure, my lord, A.
ಅದಕ್ಕೆ inquiry ಗೆ redo ಅಂತ.
He himself has not conducted the, my lord, the inquiry. My
Now,
lord, in terms of 43(6) of Endowment Act. They themselves say that, my lord, it is conducted by the, administered by the Jain community.
Now, proceedings under 42 is taken up by you.
Yes.
Where is the foundation for that?
43 and
43 ಆಯ್ತು. When we want to declare the institution on the ground of mismanagement or the complaint that he has, where is the foundation? That is the report.
that is the reason we have sent, the commissioner has sent it back, inquiry the matter and submit the report to the commissioner.
Kindly say annexure F.
And
my lord.
They have
40
not done.
43(6), any person having interest should be given opportunity.
That's the reason. That is the reason we
Kindly
are
say annexure
given an
F.
opportunity.
Again, we will observe all that. You go before the,
Before that, my lord, I will, one submission.
We will consider. and we will
Annexure F,
pass
my
it.
lord, annexure F.
page.
Page number 41. my lord.
Notice 3/4/23.
My lord, in the last 1, 2, 3, 4, 5, 6, last, from fourth, sixth line from bottom, my lord, first paragraph. ಸಾರ್ವಜನಿಕ ದೇವಳವೆಂದು ಘೋಷಿಸಬೇಕಾಗಿ ಮತ್ತು ದೇವಳಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ಖಾಸಗಿ ಟ್ರಸ್ಟ್ ನಿರ್ಮಿಸಿದಂತೆ ತಡೆ ನೀಡಬೇಕಾಗಿ ಟ್ರಸ್ಟ್ ನಿರ್ಮಾಣದಲ್ಲಿ ಆದಲ್ಲಿ ಭಕ್ತಾದಿಗಳಿಂದ ಸಂಗ್ರಹವಾದ ಹಣ ಹಾಗೂ ದೇವಳದ ಆಸ್ತಿ ಚರ ಸ್ಥಿರ ಸ್ವತ್ತುಗಳು ದುರುಪಯೋಗ ಪಡಿಸುವ ಸಾಧ್ಯತೆ ಇರುವುದಾಗಿ ಭಕ್ತಾದಿಗಳ ಉಲ್ಲೇಖ. ಸಾಧ್ಯತೆಗಳು. I created below trust on January. The proceedings is initiated in February. This is only upon anticipation, my lord.
That's right.
ಸಾಧ್ಯತೆಗಳಿರುತ್ತದೆ.
Yes, Ravi Shankar.
I am the managing president of the committee.
Another, my lord. Kindly say annexure H, my lord.
Yes. One month you came to conclude, is it? That mismanage ಆಗುತ್ತೆ ಅಂತ.
That's why.
Premonition.
That is the reason the commissioner has recommended done the inquiry.
ನಿಜವಾಗ್ಲೂ ಮಿಸ್ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಆಗೋ ಕಡೆ ಸುಮ್ಮನೆ ಇರ್ತೀರಾ?
Annexure H, page number 45. It is a statement given by the president, earlier president.
ಯಾರು ಇವರ?
ಇಲ್ಲ ಇವರಲ್ಲ, ಇವರು ಮೊದಲಿನವರು. He is having some vested interest, my lord.
ಆಯ್ತು ಅಷ್ಟೇನಾ? Yes, Ravi Shankar.
Annexure H, page number 45.
Under the scheme of section 42, kindly have a look at.
It is too early to decide that they have mismanaged.
My submission before this court that the writ petition itself, it is a premature in nature.
No problems.
Let kindly have a look.
Your
at
complaint is also premature, government's action is also premature, so is the writ petition.
43(6).
Correct?
43(6).
Should be heard ಅಂತ ಇದೆ.
To be heard.
ಹುಟ್ಟಿದ ಒಂದ್ ತಿಂಗಳಿಗೆನೆ ನಿಮಗೆ ಮಿಸ್ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
The state government has not taken any action. Under section 43(6), a report has to be submitted to the deputy commissioner, then he has to forward to the competent authority, then the government takes a decision either to declare or not. The question is whether he is heard in the matter or not. The sole ground on which the writ petition has been entertained, that he has not been heard in the matter. Though the complaints have been filed, unilaterally a decision is taken up. Now what the state government is did, the state government revert back to the file, given an opportunity, having the say, and thereafter we will take a decision.
We will set aside everything and reserve liberty if there is mismanagement in real time.
The temple has been, it has been formulated. 2023, it is time immemorial. Kindly simulate my annexure.
ಯಾವಾಗ ಹೇಳಿ ಸರ್? ಡೇಟ್ ಹೇಳಿ.
83.
1983.
83. The temple has been.
ಆಯ್ತು, ಈ ಟ್ರಸ್ಟ್ ಯಾವಾಗ ಆಗಿದ್ದು?
2023.
All right. ಆಮೇಲೆ
2023.
ಆಮೇಲೆ
now they make after the trust deed, the complaints have been received from the public.
Where?
That is what is read now.
Where is the complaint?
Yes. The state government is.
When did the complaint emerge? 2023, the trust comes into existence. Yes. What is the first complaint? Yes, Ajay, first complaint ಯಾವುದು? ನೀವು ಡೇಟ್ಸ್ ಬರ್ಕೊಂಡ್ ಬರಲ್ವಾ ಎಲ್ಲ?
ಪೇಜ್ ನಂಬರ್ 33 ಅಲ್ಲಿ we don't have any other information. ಪೇಜ್ ನಂಬರ್ 33 ಅಲ್ಲಿ ನೋಟಿಸ್ ಬಂದಿರೋದು. ಆಯುಕ್ತ ಉಲ್ಲೇಖ ಪೇಜ್ ನಂಬರ್ 33 ಮಿರೋ.
Correct. That is
ಆಯುಕ್ತ ಜ್ಞಾಪನ. That is 22 to
2023. Your trust is 27/1/23. ಆಮೇಲೆ anything else?
My vacating stay of the application on the ground that the recommendation itself, it is passed, the recommendation does not have any valid sanctity under law. The opportunity has to be granted under the act under section 43(6). That for the reason this court has granted a stay, and they have reconsidered the matter, and the matter has been remanded to the deputy commissioner to have a say. He should be given an opportunity. Notices have been issued. Everything will be considered. If the under section 42 it has been declared, the cause of action arises. Now the recommendation is there. it is been sent back to the temple, they will reconsider it. That's all my submission. In annexure R3, let the property itself, annexure R7, that the property is situated in government land, Milord. He cannot say that it is a private trust. That annexure R6.
That government will take care, don't worry.
Yes.
Yes.
It should not be
Therefore,
displayed.
Milord,
No, that government will
take care. And
83 in the government land ಇದೆ ಅಲ್ವಾ?
ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ.
ಟ್ರಸ್ಟ್ ಮಾಡ್ಕೊಂಡು ಅದರಲ್ಲಿ ಮಿಸ್ಯುಟಿಲೈಸೇಷನ್ ಆಗ್ತದೆ ಅಂತ ಹೇಳಿ
ಟ್ರಸ್ಟ್
ಕಂಪ್ಲೇಂಟ್
ಯಾವಾಗ ಮಾಡ್ಕೊಂಡ್ರು?
23 ನಲ್ಲಿ.
No problem. 27/1/23.
Yes. Now I am saying.
So 15 days ಅಲ್ಲಿ misutilization ಆಗಿದೆ.
It is premature to decide.
It was premature for you to complain also. Yes. The petitioner is before this court seeking the following prayer, heard so and so. The petitioner the averment in the petition is that the Jain community, being a minority community, is wanting to maintain and manage and administer some temples. One such temple was Sri Vishnumurti Temple, Kalenja, situated in Bailur village, Perne Post, Bantwal Taluk. The temple is said to be in existence since 1983.
15th century.
Hello, so temple is said to be in existence from 15th century. 1983 in Mata?
I'm sorry.
From 15th century. For the first time, the people of the village where the temple is situate come together and encourage forming of a trust. Therefore, the trust is formed. Therefore, the trust in the what trust is that?
Family trust.
Family
Kalanija
trust.
Guttu Vishnumurti Devasthana Trust.
ಎಲ್ಲಿದೆ ಅದು?
Page 22 of the writ petition.
Kalanjaguttu Sri Vishnumurti Devasthana Trust.
21 it seems, Milord. He has corrected it.
21.
So and so trust. Kave idralide. Page 22 al mark portion. So and so trust. The trust comes to be registered on 27/1/2023. Even before the ink on the scribe in the trust could dry, a complaint is said to have been registered by the ಯಾವ respondent ನೀವು ರವಿಶಂಕರ್?
But I am the sixth respondent.
By the fifth respondent. By the sixth respondent. Sixth respondent on 20th February 2023. Even before 23. Based upon the said complaint, it transpires that a notice was issued to the petitioner to produce all documents and appear before the authority on 7/3/2023. The petitioner is said to have appeared and filed his objections on 7/3/2023, a document which is appended to the petition. Notwithstanding the detailed objections so filed, a notice comes to be issued on 3/4/2023. The notice reads as follows, page 41. It is here the proceeding is said to have been instituted by the respondent state, invoking the provisions of the Karnataka Hindu Religious and Charitable Endowments Act 1997. The notice so issued on 3/4/2023 has driven the petitioner to this court in the subject petition. The learned counsel Ajay Prabhu, appearing for the petitioner, would submit that the trust was registered on 27/1/2023 and people who are inimical to the trust, to the formation of the trust, register a complaint 20 days after its formation, and the state has taken up the proceeding under section 42. The learned counsel would submit section 42 cannot spring into action at all in the case at hand and therefore seeks quashment of the entire proceedings. The learned counsel, AGA appearing for this, state would submit that in fact the proceedings that were taken up by the deputy commissioner was erroneous, and therefore the matter has been remitted back to his hands to hear the petitioner and then pass necessary orders in accordance with law. And therefore the petition is premature and the petitioner will have to participate in those proceedings before the deputy commissioner as is directed by the commissioner today. the learned counsel Ravi Shankar representing the sixth respondent would also toe the lines of the learned AGA in contending that that violation of principles of natural justice or violation of subsection 6 of section 43 has led the deputy commissioner has led the deputy commissioner to redo the exercise. Therefore, the petition is premature. I have given my anxious considerations. The afore narrated facts are not in dispute. The dates and the link in the chain of events are as follows. The temple that is the subject matter of the petition is of 15th century, is a matter of record. The trust that is formed for the maintenance of the temple is on 27/1/2023 is again a matter of record. Barely after 20 days comes a complaint. The complaint alleges mismanagement. On the complaint, a notice is issued by the state. Reply is submitted by the petitioners. Reply is found to be unsatisfactory. A subsequent notice comes about on 3/4/2023, which is quoted supra.
Annexure N also, one more notice.
Quoted supra. Not stopping at this, another notice is also issued by the state. All of this has led the petitioner to this court in the subject petition. The issue is whether the state could have instituted proceedings under section 42 for declaring the institution as the institution to become a declared institution. Therefore, the section 42 and 43 read as follows. Section 42 mandates that the state government, where it is satisfied on a report of the commissioner under 43 or otherwise of any Hindu religious institution, whether or not governed by a settled scheme, is being mismanaged. The soul of the provision is that the institution should be mismanaged. Once it is for prima facie found that it was mismanaged, a notice to show cause on the said report is to be issued to the person who is going to be affected by any order that would be passed as obtaining under subsection 6 of section 43. The issue in the list is there is no foundational report of any mismanagement by the deputy commissioner or the commissioner, as the case would be. What is in the hands of the state is a complaint registered by the sixth respondent, barring that there is not even a titter of material before the state that the institution is being mismanaged. Within 20 days, the state appears to have been drawn into the complaint of the sixth respondent that the institution is likely to be mismanaged by the petitioners. In anticipation, a proceeding under section 43 to declare an institution under 42 cannot spring. The state has acted in undue haste to issue notices and start proceedings under section 42 of the Act, all owing to a complaint of the sixth respondent without there being any material as observed herein above. Therefore, the submission of the learned counsel Ravi Shankar and the state that the proceedings are now instituted by the state and in compliance with subsection 6 of section 43, and therefore the petitioner should participate, is a submission that does not merit any acceptance, as there is no foundation prior to institution of the proceedings for declaration that the institution is mismanaged, except the complaint as observed herein above. Therefore, the entire proceeding instituted by the state suffers from want of bona fides. In that light, the petition deserves to succeed. Allowed, quashed. Yes, next. 20 ದಿವಸದಲ್ಲಿ ಡಿಸಿಷನ್ ಬಂದೇ ಬಿಟ್ರು, ಮಿಸ್ಮ್ಯಾನೇಜ್ ಆಗ್ತದೆ. ಆಂಟಿಸಿಪೇಷನ್ ವಾಟ್ ಸ್ಟೇಟ್. ಎಸ್
For petitioner, my lords. MOB, my lords.
Yes, sir. Modus operandi bureau.
Your lordship, there were two cases against him.
ಅದಕ್ಕೆ modus operandi bureau ಗೆ ಹಾಕಿ. Where is the proceeding?
It comes under the classification because he was.
Where is which is the act?
Policeman.
Policeman.
17.
Fake currency, na?
Got acquitted in the year 2012, my lord.
ಆಗಿದ್ದಾನೆ. ಎರಡು ಕೇಸಸ್ ಇಲ್ಲ.
ಕೊಡಿಲ್
But our classification ಅಲ್ಲಿ ಬರ್ತಾನೆ.
ಪೊಲೀಸ್ ಮ್ಯಾನ್ಯಲ್.
MOB registered only against the history sheeter, my lord. It says, it provides.
ಕೊಡಿಲ್. Clause
1720, my lord.
modus operandi. If a history sheeted person has been out in view, traced or arrested entries, register is maintained for pointing out the investigating of possibility of an out of view criminal for a particular ಈಗ ನಿಮ್ದು 489 offense
Yes, my lords.
ಯಾವಾಗ acquit ಆಗಿದೆ ಯಾವಾಗ?
My lords, acquitted on
In CC?
Special case
Oh,
number
special case,
54 of
yes.
2011, my lords. Acquitted on
No, special case?
54 of 2011. Acquitted on
Second.
21/2012, my lords.
When was your name drawn in the MOB?
My lords, in the year 2010 itself. Annexure A, my lords.
Anything else, sir? The petitioner is before this court seeking the following prayer. Heard so and so. Facts in brief germane are as follows. The petitioner, a resident in Kalsa, Mudigere, gets embroiled in a crime number 62 of 2010 for offences punishable under section 489 A, B and C, ABCDE of the IPC. The petitioner is tried in pursuant to the registration of the crime. The name of the petitioner is drawn in the MOB register - Modus Operandi Bureau register in MOB number 438/15222. The petitioner on a full-blown trial in SC 54 of 2011 gets acquitted in terms of the order passed by the concerned court on 2/1/2012. 2/1/2012. The petitioner then represents to the respondent police station to take off his name from the Modus Operandi Bureau register, as that is creating ಏನಿದು ಒಂದು ಕಾಲ್ ಬಂತ so and so which is hindering.
Yearly they summon them.
Sorry, one ನಿಮಿಷ. The petitioner on 19 The petitioner on 19/8/2024 was summoned by the police as annually a person whose name is drawn in the Modus Operandi Bureau gets summoned from the jurisdictional police. It is then the petitioner is before this court seeking removal of his name from the Modus Operandi Bureau. The learned counsel Ketan Kumar, representing the petitioner, would submit that 12 years ago the petitioner has been acquitted. There is no other case pending against him for his name to be drawn or kept in the MOB Bureau. He would seek its removal by a direction at the hands of this court. The learned AGA Rahul Karyappa would seek to defend the action on this score that his offense against him was counterfeiting currency as obtaining under section 489 ABCDE.
And the Wildlife Protection Act.
And adeliದೆ case.
ಅದು ಸೇಮ್ ಇದ್ರಲ್ಲೇ.
And offenses under the Wildlife Protection Act.
And it comes under the classification 8 of the
Wildlife Protection Act, which was he would submit that the name of the petitioner should remain as an out of view criminal, as propensity to commit the offense all over again is writ large in the case of the petitioner. He would therefore seek dismissal of the petition. I have given my anxious ones. The afore narrated facts are not in dispute. They would not require any reiteration. The issue in the list is whether the name of the petitioner drawn into the Modus Operandi Bureau could be sustained even today for it to remain in the registry, in the said registry. Drawing up of a name of a criminal under the Modus Operandi Bureau is dealt with under clause 1720 of the Karnataka Police Manual. It reads as follows. A name can be drawn into the Modus Operandi Bureau if a person is history sheeted who has been out of view and is traced or arrested. The entry or the entries relating to him should be scored out from the relevant registers, and the date on the date of tracing or arrest should be noted in the remarks column, is what is mandated under subclause 2 of clause 1720. It is an admitted fact the petitioner gets embroiled in a crime in the year 2010 for the aforequoted offences. It is again an admitted fact that after a full-blown trial, the petitioner gets acquitted of the offences in SC 54 of 2011. The 2011. Therefore, on and from that date, the petitioner is holding the acquittal on his sleeve and is holding an acquittal on his sleeve. But what remains is the name of the petitioner that was drawn into the Modus operandi Bureau register on 19/6/2010. 13 years have passed by. The learned AGA is not able to point out any offense that is committed by the petitioner after 2012, that is after the date of his acquittal. Therefore, keeping the name of a citizen under the Modus operandi Bureau and summoning him to the police station every year on the score that his name is in the Modus operandi Bureau undoubtedly affects the right of the petitioner, right of any citizen, and in the case at hand, the petitioner. In that light, the petition deserves to succeed, and the prayer to be granted to the petitioner allowed so and so. The writ petition is allowed. The mandamus issues to the respondents 4 and 5 to delete the name of the petitioner from the Modus operandi Bureau maintained before the respondents 4 and 5 from their records without broking any delay, at any rate within 4 weeks from the date of receipt of the copy of this order. Yes. Yes. Next.
Return of bank guarantee method side. Given the bank guarantee is expired, contract is terminated. My OTS with the bank is withheld.
Yes, sir.
Lord, we wanted to invoke that bank guarantee. Lord, they end up filing an arbitration suit. They get a stay, my lord, in arbitration application, my lord, under section 9. They stay that, my lord. It's been over 10 years. Now, my lord, they have not appointed an arbitrator. And the order, my lord, there said that till the arbitration is decided, we cannot invoke a bank guarantee. So there is a dispute.
Where is the arbitration pending?
My lords, the invocation is done, my lords. There have been 3 instances.
Invocation yavaga?
My lords, in 2017 only invocation was done. Thereafter, my lords, the arbitrator, the nominee arbitrator passed away. Then, my lords, we've been communicating with the department for them to appoint an arbitrator, not done. They have not raised the counterclaim. My lords, as on date, there is no counterclaim.
Yes. List the matter after 2 weeks.
My lords, may make this request.
No,
my lords, now the bank guarantee is expired. My lords, they have not asked me to renew the bank guarantee either. They don't have a claim as against me, my lords. If the bank guarantee is written to me, my OTS with the bank.
Subject to arbitration. Yes.
My lords, I've already invoked arbitration. My lords, they have not responded. My lords,
list after 2 weeks.
My lords, only one submission. My lords, the last annexure may be taken. My lords, I've already invoked arbitration. I've requested for the commencement of arbitration. They have not responded. My lords, I need to initiate CMP now, which I will do.
Please do it. You have taken 7 years to do it.
No, my lords.
Please do it.
In the meanwhile, my lords, if the instrument, my lords, as on today is expired.
It is expired. Why are you worried?
My lords, I need the original for me to give it back to the bank. So that, my lords,
arbitration. Take steps to invoke arbitration and get an order at the hands of the arbitrator.
The only difficulty is this, I was in CIRP. Now, my lords, that I've been able to close it by way of an OTS. The bank, my lords, wants the original bank guarantee for them to finalize the OTS. Only for that, my lords, may I?
Matter may be disposed of on those observations.
Let him initiate.
I'll initiate. I'll file the CMP and then, my lords,
yes. The petitioner is before this court seeking the following prayer. The learned counsel.
I'll initiate the CMP, my lords, let the matter be pending, my lords.
All right. List the matter in the first week of June 2025.
I'm grateful.
17 minutes, so the petitioner has been enrolled on.
I pay for the petitioner minutes.
He has been enrolled on 28 minutes.
Huh?
He has been enrolled on 28.
Enrolled. Yes.
I pay for the petitioner, please, minutes.
The learned counsel TP Vivekanand, appearing for the Karnataka State Bar Council, would submit, and the council so and so would submit that the petitioner has been enrolled on 28th March 2025. In that light, the petition, the prayer in the petition is redressed and the petition has become infructuous. Is disposed as having become infructuous. Next.
Grateful minutes.
ಇದು page 234 covered?
Survey number 3.
And yes, page 234, same order.
FIR should also go. I have sought.
ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಇದೆ ಅದು? ಅಲ್ಲಿ ಒಂದು ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಆಲ್ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಆಕ್ಷನ್ಸ್ ಟೇಕನ್ ಪರ್ಸ್ಯೂಯಂಟ್ ಟು ದಿ ಸಬ್ಜೆಕ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವುಡ್ ಆಲ್ ಬಿಕಮ್ ಎ ನಲಿಟಿ ಇನ್ ಲಾ. ಎಸ್, ಒನ್ ಕ್ಲಾಸ್.
Including the FIR.
ಆಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂದ್ರೆ ಏನು?
ಅರ್ಥ ಆಗಲ್ಲ ಇಲ್ಲ ಅಂದ್ರೆ.
ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಕೇಸ್ ತೊಂದ್ರೆ. ಎಸ್.
ಬೇಡ.
ಪೆರೋಲ್ ಏನು?
Life premature release, my lord.
Premature release.
It's covered by
Omkar Murthy.
Omkar Murthy, sir.
Your lordship, the last date of hearing had made a submission that his name has not been recommended by the advisory board, and he had assaulted the.
ರೆಕಮೆಂಡ್ ಆಗಿಲ್ವಾ?
My lord, ಆಗಿದೆ 19 years 7 months ಆಯ್ತು.
ಆಯ್ತು, ಈಗ ಪೆರೋಲ್ ಮೇಲೆ ಬಿಡೋಣ.
Because of frustration he has.
Frustration.
He did. ಎಲ್ಲರೂ 14 ವರ್ಷದ ಮೇಲೆ ಬಿಡ್ತಿದ್ದಾರೆ, ನಮ್ಗೆ 19 ವರ್ಷ ಆಗಿದೆ ಅಂತ. Due to that he showed in a different mean, my lord. It's not supposed to do, but he did.
Yes, the petitioner is before this court seeking the following prayer. Heard so and so. The petitioner gets embroiled in a crime and is tried for offense punishable under section 302 of the IPC. He is taken into custody on 15/7/2007 and on his conviction remains in custody. As on 1/8/2024, the petitioner had completed 19 years and 7 months in prison. Today more than 20 years. The petitioner committee ಅಲ್ಲಿ ಯಾವಾಗ ಮೀಟ್ ಕಮಿಟಿಗೆ ಮುಂದೆ ಹೋಗೇ ಇಲ್ವಾ?
ಇಲ್ಲ, advisory board has not recommended.
The counsel for the petitioner submits that the case of the petitioner was taken up by the advisory board for recommendation of premature release, but was not considered on the score that he has assaulted a policeman inside the jail, or doctor inside the jail, as inside the jail, and the petitioner learned counsel would submit that it was due to frustration of every other convict being released and not him. Be that as it may, the petitioner is, as observed herein above, the petitioner is before this court seeking premature release, which cannot be considered at this juncture unless the advisory board would recommend his name for premature release, which has not yet happened in the case at hand. In that light, I deem it appropriate to grant the petitioner parole for a period of 60 days to become operational from Friday, with liberty to the petitioner to seek its extension on his conduct while he is outside on parole on certain conditions. Yes.
So grateful, kind of.
Next.
20.
Disconnect ಆಗಿದೆಯಾ?
The matter is coming up, the main matter is coming up tomorrow.
ನಾಳೆ ಇದೆಯಾ ಅದು?
This is not.
ನಾಳೆ ಆಗಲ್ಲ, ಅದು ಎರಡೂ ಸೇರಿ ಫ್ರೈಡೆಗೆ ಹಾಕ್ಬೋಣ. ನಾಳೆ ಬರಲಿ ಅದು. ಇದು ಫ್ರೈಡೆಗೆ ಹಾಕಿರಿ, ನಾಳೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ ಇದರಲ್ಲಿ.
Same order as.
List the matter on Friday along with connected cases. Entry order as prayed for till the next date of hearing. Next. Yes.
Serial number 20, 21 and 42. Same matter.
20, 21.
Lord, this is not like disconnection. This is the acquisition of land.
This is KB overhead.
Oh, the compensation.
Compensation.
Then
We are challenging the entire acquisition.
Notification.
how can you challenge it here?
My lord, interim order is granted in the main petition, which is coming up tomorrow. Status quo has been ordered.
ಹಾಗಾದ್ರೆ ಒಂದು ಕೆಲಸ ಮಾಡಿ. List the matter on 4th along with numbers ಕೊಡಿ. So and so in the fresh matters list, the status quo where the property be maintained till the next date. I will not hear the respondent, but you will have to convince on continuance of the interim order on Friday. Don't hinge upon what he would say. I want you to convince, otherwise I'll dismiss the petition. Yes. Next.
20, 21 and 42.
20, 21 and
42.
42. ಮೂರುನು ಅದ್ರ ಜೊತೆ ಹಾಕಿ. Yes. Next.
22.
Serial number 22 and 22.2.
Respondents in all the cases.
Hmm.
Serial number 22.
That is a writ petition 7557 of 2020.
ಏನ್ ಹೇಳಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಯಾರು ಕೇಳಿದ್ದೀಗ?
I have challenged the sale notice, Your Honor.
ಸರಿ,
And,
ಸೇಲ್ ಆಗೋಗಿದ್ಯಾ?
ಅದು ಇಲ್ಲ,
Along
ಸೇಲ್
with the-
ಆಗ್ಲಿಲ್ಲ ಅವತ್ತು.
ಹಾ.
For the petition has become infructuous.
ಆಲ್ ರೈಟ್. ಯಾವ್ದಿದು ರಿಟ್ ಪಿಟಿಷನ್
7557 of 2025.
ಸೇಲ್ has not
That is
taken place.
22.1 also challenges the sale notice.
So both infructuous.
Both have become infructuous now. Now the only writ petition
22.2.
ಅದೊಂದೇ
ಇದೇನು?
consideration ಗೆ. That possession order is challenged.
Serial number
Let them make
22
their submission.
Serial number 207557 ಅಲ್ಲಿ my prayer, another prayer is there, Your Lordship.
OTS.
With the repossession.
ಅಲ್ಲ repossession ಕೇಳಿದರೆ that prayer is already under consideration in 22.2. Because an IA is filed in 22.2 seeking repossession.
Let me see, 1 minute.
I should be permitted to read out the.
1 minute, sir. Prayer ಏನ್ ನೋಡ್ತಾರೆ? Sale notice dated 12/2/2025 is the prayer in 7557. That has become infructuous today. Next petition. 13982 of 23 ಅಲ್ಲೇನು?
ಅದರಲ್ಲೂ ಅಷ್ಟೇ ಸೇಲ್ ನೋಟಿಸ್ way back in 2023.
Yes, that also has become infructuous.
ಅದು infructuous
Next, ಈಗ 10160 ಅದೊಂದೇ ಉಳಿದಿರೋದು, ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ?
I should be permitted to read out the sequence of events happened.
Which case, sir?
In 10160.
Wait, we will first dispose these two. The 22 and 22.1.
One submission. Before disposal, I should be.
ಏನ್ disposal? I am saying it has become infructuous.
That's what I'm afraid for the position of the property in that one.
No, sir, sale notice challenge ಮಾಡಿದ್ರೆ ಅದೋಗಿದೆ 22.2 ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರೋ ಇಲ್ವಾ ಅದನ್ನ?
ಮಾಡಿದ್ದಾರೆ.
The petitioner, ಇದು ಎರಡು prayer quote ಮಾಡಿ madam, ಇದು 22, 22.1. The learned counsel appearing for the respondent bank submits in both these cases what is called in question is a sale notice. The sale notice of the year 2023 and the sale notice of the year 2025. On both the dates, the sale has not taken place, and therefore the date of auction has spent itself. The petition is thus rendered infructuous on the ground, on the score that the sale has not taken place on the intended date and is disposed as having become infructuous, reserving liberty to the petitioner to knock at the doors of the appropriate fora in the event of need. Now come to 22.2. Yes, Kodiya.
In 22.1, this honorable court had granted an ad interim order of stay, asking the petitioners to deposit 1 crore 8 lakhs in
Madidara?
3 installments. Not a rupee has been paid till date. Let
correct.
them make their submissions because they have filed a synopsis. Then I will make my submission.
Yes, sir.
22.1.
Like, really, but it is the same petitioners.
Borrower is the same, sir.
Or is the same. Your Lordship, on 14/2/2019, mortgage loan was done.
Sir, you don't go Constitution 1950 ಅಲ್ಲ, ಏನ್ ವಿಷಯ ಹೇಳಿ? You can't keep on arguing the matter. ನಾನು ಲೋನ್ ತಗೊಂಡೆ, ಲೋನ್ ಕಟ್ಟದೆ. Default ಯಾವತ್ತಾಯ್ತು, what is the amount in due ಅಷ್ಟೇ, ಇಲ್ದರೆ go before the DRT.
4 crores 28 lakhs odd is due from the petitioners.
18/8/2023 ನಲ್ಲಿ ಒಂದು ಲೆಟರ್ ಆಫ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾರ ಜೊತೆಗೆ ಸರ್?
Along with the bank.
ಏನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ಸ್?
According to it. At page number 1 to 10, Your Lordship.
1?
Page number 1 to 10.
1 to 10 na?
Document number 1, page number 1.
Document number 1?
In 22.2, they have filed a synopsis, and along with that synopsis, they have produced 3 documents, if I've understood correctly.
Yes, sir.
Your Lordship, page number 2, para number 1, Your Lordship. First party and the second party has mutually agreed to resolve all the legal issues filed against each other on goodwill and will not further challenge each other legally. Accordingly, the first party has agrees not to continue with the prayer filed in respected High Court with the writ petition 13982/2023. And further, third point, Your Lordship, second party acknowledges and accepts the same to resolve on mutual discussion without any demand or conditions from first party as directed in writ petition 13992 by 2023. So other prakara Swami, para number 15, page number 7, your lordship. Para number 15, lordship. As per the agreement of understanding by both the parties, first party to pay only a total sum of rupees 55 lakhs in cash.
55 lakhs ಕಟ್ಟಿದ್ದೀರಾ? ಆಮೇಲೆ
Second party, between the period August 2023 to February 2024, with the minimum of 5 lakhs each month in the specified duration months, and to complete 55 lakhs within February 2024. Proof has also been furnished, your lordship, with respect to the payment. The subsequent para.
Yes, sir. You agreed on anything,
Now
discharge
they
the
have
discharge the market did also, then what are you handing?
Now that they have relied on these documents, it becomes very easier for me. Document number 1 and document number 3 are fake, created, fabricated documents. These are counterfeit documents. This was never issued by the bank. These are my explicit submissions. And
Which document, 1 and?
document number 1 and document number 3. The authorized officer will be filing an affidavit as well as the branch manager. We'll be pursuing a criminal complaint against the petitioners.
Have you registered one?
Sorry?
Have you registered the crime today?
No, this was produced.
Criminal case
last
register ಮಾಡಿ.
ಲಾಸ್ಟ್ ಡೇಟ್ ನಲ್ಲಿ ರೀಚ್ ಆಗಿಲ್ಲ ಮ್ಯಾಟ್ರು ನನಗೆ
ಅವತ್ ಕೊಟ್ಟಿದ್ದ ಇದು?
ಅವತ್ ಕೊಟ್ಟಿರೋದು ಕೊಟ್ಟಿರೋದಲ್ಲ ಇದು.
ಅಲ್ಲಿವರೆಗೂ ಗೊತ್ತಿರಲಿಲ್ಲ.
ಅಲ್ಲಿವರೆಗೂ ನನಗೆ ಗೊತ್ತೇ ಇರಲಿಲ್ಲ ದೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಕ್ಸಿಸ್ಟ್ ಅಂತ. I was wondering all along if they make their submissions that 55 lakhs has been paid. Account statements are not reflecting a single rupee. So I was wondering all along, where is this amount?
55 lakhs, just one moment. ಈಗೆಲ್ಲೋ 55 ಲಕ್ಷ ಓದಿರಲ್ಲ ನೀವು?
Para number 15, your lordship.
Page number
7.
1 minute. This is between the bank and you, alla?
Yes, sir.
Bank and the petitioners.
One minute. Which bank official has asked you to deposit 55 lakhs in cash? ಅವ್ರ ಪಾಕೆಟ್ ಕೊಟ್ರಾ ಇಲ್ಲ ಅಕೌಂಟ್ ಕೊಟ್ರಾ?
Account ಗೆ sir.
ಎಲ್ಲಿದೆ?
Cash ಅಲ್ಲಿ ಕೊಡಕ್ಕೆ.
ಎಲ್ಲಿದೆ? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ? Acknowledgement ಅಲ್ಲಿ, account statement ಅಲ್ಲಿ. Which bank will say you pay 55 lakhs by cash?
Yes, your lordship. Because they were in the driver's seat. They were in the dominating position.
Oh,
So,
seriously?
I had to relieve myself from the.
Seriously? Yes.
These documents would amount to perjury.
Wait, sir. Yes. 55 ಲಕ್ಷ ನೀವು ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಏನಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್?
I would like to.
ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಏನಿದೆ?
Number 2.
55 ಲಕ್ಷಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಏನಿದೆ?
Number 2 is release of property, your lordship.
Release of property.
Yes.
ಯಾವ ರಿಲೀಸ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ?
That's what I would like to bring the kind notice of this.
Which release of property, sir?
Page number 7 ಅಲ್ಲಿ 16 para number.
After receiving 55 lakhs in cash.
Yes, your lord. From first party, the
Yes,
second
sir.
party agrees to execute release deed or schedule B property.
Oh, very
mentioned
good.
below, schedule
Anything
B
else,
property
sir?
deed. ಇದನ್ನ ರಿಲೀಸ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಎಲ್ಲ ಬೋಗಸ್ ಡಾಕ್ಯುಮೆಂಟ್.
No, your lordship, no. It is registered.
I'll explain the circumstance of these discharge deeds as well.
Why did you execute discharge?
There are two portions of this property. The eastern portion is a vacant site. The western portion is a residential house. Both properties are amalgamated for the purposes of tax. Now, the petitioners approached the bank in 2023 asking for a standard asset letter because they intend to sell the eastern portion, which is a vacant site, to a prospective purchaser and settle the sale consideration arising from the sale to the bank. Now, when the
ಈಗ ಇದರಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನು?
possession order.
DRT go. Yes. Anything else, you go before the DRT. He alleges fraud. I cannot sit here and decide fraud.
Another submission.
I may be permitted to file an application under.
ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದೆಲ್ಲ.
Please, because.
Para number 20 at page number 9, your lordship.
Which bank manager will ask you to give 55 lakhs by cash?
In the letterhead, there is a letter of understanding. Which bank would even execute such a document?
One thing, 55 lakhs ಯಾರು ಕ್ಯಾಶ್ ಅಲ್ಲಿ ಕೊಡಕ್ಕೆ ಹೇಳ್ತಾರೆ?
No,
Go before the DRT.
Lordship, I would be.
Go before
permitted-
the DRT
I
for
will be
anything.
permitted to read out the para number 20, page number 9, Your Lord.
Go before the DRTs. Any, all seriously disputed questions of fact. We will not decide this here.
In 22.2, I may be permitted to file an application for perjury because the documents are produced on
But
record.
in
my
Bekar
lords.
Madi, sir. I am closing this petition permitting him to approach the DRT if a possession notice challenge ಮಾಡ್ಕೊಂಡು ಮಾಡಿ. No, sir, I am not retaining this.
Lordship, para number 20, page number 9, Your Lord. Because the sale notice issued by them according to this.
Challenge it before the DRT.
Understanding
The,
is in the respect of the old
Old
one.
notice. After that.
you
New loan
challenge,
has
you
come
challenge
into
everything before the DRT, sir.
Liberty should be given. Your Lord.
Correct, sir. Yes. The petitioner is before this court calling in question an order under section 14 of the Surface Act 2002 dated 2/1/2024 in criminal miscellaneous 6284 of 2023. The learned counsel appearing for the petitioner would take this court through the additional documents that are filed along with a synopsis
Can I
to-
make one submission?
to demonstrate, DRT madam,
One
to
submission,
demonstrate that the loan, that there was a memorandum of understanding between the bank and the borrower. And in terms of the memorandum of understanding, the discharge deeds have been, discharge of mortgage deeds have been executed. The learned counsel for the respondent.
Lordship, sorry for interference. One submission, Lordship. I may be, since the matter requires the technical matter, I may be permitted to engage senior counsel, Lordship. If my-
ಯಾವುದಕ್ಕೆ? ಇಲ್ಲ, this I am not keeping, yes.
Lordship, one submission.
No, madam.
The discharge deed is the it's a judicially noticeable.
There is a technical senior counsel here, is it?
ಅಲ್ಲ, ಹಾಗಲ್ಲ
Then-
ಸ್ವಾಮಿ. It's judicially noticeable facts. It is registered before the sub-registrar.
No, that we'll see. I am reserving liberty to challenge so and so. The learned counsel.
Limitation ಪ್ರಶ್ನೆ
The
ಬರುತ್ತೆ.
learned counsel for the respondent would, learned counsel for the respondent would submit that the documents that are produced along with the synopsis are fake and he be reserved liberty to initiate such proceedings for producing such fake documents. Liberty is reserved to both the petitioners to act in accordance with law and if available in law. The learned counsel for the petitioner is at liberty to call in question any subsequent action of the bank before the DRT or the impugned action before the DRT in accordance with law. Reserving such liberty, the petition stands disposed.
I may be reserved liberty to
Yes.
initiate criminal complaint against them as well
ಅದಕ್ಕೆ
as.
ಯಾಕೆ ಲಿಬರ್ಟಿ ಬೇಕು ಕಥನೆ? ಎಲ್ಲದಕ್ಕೂ ಲಿಬರ್ಟಿ.
ಅಲ್ಲ, it may be at least noted that these
I've
fake documents
I've
are
already noted fake ಅಂತ ಅಷ್ಟೇ.
Lordship, one submission. Whether it's fake or not, it's a matter of trial is my humble.
Correct, ಅದನ್ನ trial ನಾನೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಲ್ಲಿ fake ಅಂತ. Alleged fake ಅಷ್ಟೇ ಅದು. Yes.
It's registered before.
No, that's all right. We'll see. Yes. Next.
It's agent 24.
While your objections.
Well, this single bid is recalled.
Single bid ಅಷ್ಟೇನಾ?
Is recalled. He has a grievance for that while call 2 is being done. He's participated in call 2 also. Financial bids are pending.
Anything else, sir? Single bid ಇದ್ರೆ recall ಮಾಡ್ಬೇಕು, ಏನ್ choice ಇಲ್ಲ.
Senior ಇದು division bench argument ಮಾಡ್ತಾರೆ.
ಆಯ್ತು ಸರಿ. List on Monday in the fresh matter.
Along with WP number 2306 of 25.
Tag along with WP number
2306 of 25.
2306 of 2025. Yes. List on Tuesday and Monday. But next.
25.
Kindly have it for tomorrow, madam. Some inconveniences.
Yes, Shantibhushan sir, ಏನಿದೆ?
He wants it for tomorrow. The reason is this, my lord. A crime was registered against him. Lord, he was convicted for 1 year. Lord, he approached the apex court, reduced to 2 months. That order, my lord, he has to produce it. Let him, he's saying that, my lord.
Then he's entitled to regular validity passport.
He's entitled, my lord, since he's, my lord, that.
ಎಲ್ಲಿದೆ
only-
ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆ.
The Supreme Court order does, page 17, it does not say for which case, my lord. Therefore, I requested him, you please tell me that which is that case. He told he'll get it tomorrow.
Right. List on Friday.
Fresh matter.
Fresh matters. Yes, next.
Great.
26.
Petitioner, Lordship. this is a matter arises where my movable goods are seized by the bank, wherein I am not the, I'm a third party to the loan. I'm as far as the original application filed by the bank against the mortgage property.
Which is the property in mortgage?
Scheduled property, but these mobile goods are not hypothecated. Your file matter original application.
Why are you before this court?
My goods are seized by the bank.
Seized?
That in that mortgage property.
Possession is taken, sir.
Please, please, possession authority.
Pursuant to what?
Pursuant to the CMM order.
No, then
This
what's wrong with it?
loan was borrowed in the name of my brother. My brother is the borrower.
That is not the
He has
issue.
mortgage
What is the property in mortgage?
Immobile
Nim brother.
property. Immobile property. Immobile property.
Then what is the movable inside vehicles? Huh?
ಇಲ್ಲ, ಇದು Copra.
ಅದನ್ನ ತಗೊಂಡೋಗಿದ್ದಾರ?
Perishable goods.
Yes,
That
ma'am.
is the- when
My
we
lord,
have the original application for reference.
ಕೊಡಿ.
This is the original of application.
Filed by the bank.
Filed by the bank before the DRT.
My lord, let me make
Kindly
a
turn to
sum.
page, kindly turn to page 18. That's the schedule of the OA. In the schedule of the OA, no movable goods are mentioned. Only immobile property is mortgaged. Page 18. Further.
Now what is seized?
Hypothecation deed alone, they don't say.
Where is
they
the
don't say-
hypothecation deed?
Page 29 of that same bunch. Page 29 of the same bunch. Adrallono, illono, the hypothecation, ileno illa illi. They haven't mentioned anything. These mobile goods are not part of the loan at all. In for further supplemental deed ಇದೆ ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಅದರಲ್ಲೂ there is no mention of it at page 34.
ಈಗ ಸೀಜರ್ ಮಾಜರ್ ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಪೇಜ್?
ಅದು ನಮ್ಗೆ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಅವರು.
ಈ ಕೊಬ್ಬರಿ ಸೀಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ?
In my representation at annexure A.
Page 12.
Please, page 12. ನನ್ನ ಸಂಸ್ಥೆಯಲ್ಲಿ ಹೊಂದಿದ್ದು ದಿನಾಂಕ 31/1/20.
ಎಷ್ಟು ಕೊಬ್ಬರಿ?
It's about worth about 22 lakhs, about 40 sacks of copra.
My lord, let me make a submission.
You want to manufacture coconut oil?
Not
Then?
because of that, my lord.
Yes.
This particular business was run by Akana Traders, which is his brother.
What is the property in mortgage?
Property mortgage is the
Immovable property or movable assets?
immovable property plus the movable
Where
assets.
is the plus?
Yeah,
Where is the plus?
I shall produce the document wherein the brother had given a.
Now
letter
what
to
is
the-
this? What is the
to the
status of
bank
this?
stating that
ಕೊಬ್ಬರಿ ಏನ್ ಮಾಡಿದಿರಾ ಈಗ?
we have sold the in the auction.
When did you conduct the auction?
That I will have to check with the
And
bank.
where are the proceeds of the auction?
I shall produce.
The petitioner is before this court seeking, calling in question an order passed by the learned magistrate under section 14 of the Surface Act 2002 and has sought restoration of possession. Physical possession ತಗೊಂಡಿದಾರಾ? Restoration of possession
Let me make
of the property along with of the property.
Let me make a submission because there was earlier a petition filed by the brother that is numbered as 19051 of 2021. My lord.
No
in that-
problem. That is, see, physical possession of the property you take.
No, physical possession was restored to take back the perishable goods by the brother.
Perishable goods were permitted by this court?
Yes,
Where is
yes,
it?
my lord.
Where is it?
In writ petition number 19051 and 2021.
Page. You have not produced that?
In my file, I've stated that in my petition.
Where is the order? ಯಾಕೆ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ಲ? ಅದ್ರಲ್ಲಿ ಏನೋ ನಿಮ್ ಅಗೇನೆಸ್ಟ್ ಇದೆಯಾ? ಮತ್ತೆ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ?
Earlier, I was conducting business in a joint fashion.
Did this court permit seizure of perishable goods?
It released the property. It
No,
released the
perishable
movable
goods ತಗೋಬಹುದು ಅಂತ ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ಯಾ? ಅವರು ತಗೋಬಹುದು ಅಂತ.
ಇಲ್ಲ, ನಮ್ಗೆ
Not for.
ಅದಕ್ಕೆ ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ನಂಗೆ ಅರ್ಥ ಆಗುತ್ತೆ. ನೀವು ಅದು ಮಾಡೋದು ಇಲ್ಲ.
and possession was retained, taken
Madam,
back by them.
you tell me one thing.
Yes, ma'am.
The perishable goods that were inside the building, did this court permit you to take it?
No, my lord, this,
Okay, yes.
no, my lord, the problem is that the physical possession was handed back to the brother. And he has taken back the perishable goods at that point of time. Again, he is the person who is conducting, the other brother doesn't have any authority on that goods. That is the main thing. The business has been conducted by
It's
the
all
brother.
right.
my
Now,
lord.
you are the brother of the borrower or the borrower?
I'm the brother of the borrower.
How are you connected with this?
Earlier, the business was run jointly.
Earlier jointly alla. Borrower is your brother. Now you are separated after the loan becoming default. No problem.
Joint family properties.
It's all right. Yes. That you fight out with your brother. File your objections.
Yes, ma'am.
The learned counsel appearing for the respondent bank shall file the statement of objections in the next 10 days.
Petition is very much clear, your lordship.
1 minute. In the next 10 days, list the matter on 22nd. Objections, if any, by the bank by then. Till such time, no precipitative action shall be taken against the petitioner or the property. ಯಾವ್ದು ಸೇಲ್ ಮಾಡಿ ಆಗೋಗಿದೆ? ಯಾವ ಡಿಟೋರಿಯೇಟೆಡ್? ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಇದ್ದಾರೆ? That's what she's saying. That's what she will do.
The short date.
22nd, yes.
Already this date is only.
ಈಗ ಸೇಲ್ ಮಾಡಿ ಆಗೋಗಿದ್ರೆ ಕೊಬ್ಬರಿ will not become ಕೊಬ್ಬರಿ ಎಣ್ಣೆ now. Don't worry. Yes. 27. Learned counsel for the petitioner seeks leave of this court to withdraw the petition. In the light of the said submission, petition is disposed as withdrawn. Next. Office objections are still not complied? ಮತ್ತೆ ಇನ್ನು ಹೆಂಗಿದೆ? Learned counsel submits office objections have been complied with. If complied, the registry to delete the indication of non-compliance. Yes, what's the matter now? Oh, this is that investigation.
Previous order dated 25/3.
One moment, sir.
Lordship's previous order dated 25/3.
ಅದು ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
No, it records that prima facie there is no semblance of fairness in the investigation.
Correct.
A dramatic turn of events on 26th, the following day, the IO against whom we had made allegations that he was acting with complete investigative inertia, he's himself arrested in a Lokayukta case where he's caught demanding a bribe of 4 lakhs for arresting.
The investigating officer in this case.
ACP Tanveer.
All right.
Next day he's caught demanding a bribe of 4 lakhs.
Connected to this case?
Not to this
different.
case.
There can be.
It's all right. Fine. Yes, he has got. Now, what he is trying to submit is with regard to fairness of investigation.
No, you're not of fairness. Now there is clear, outright evidence of misconduct and unfairness in the investigation.
No.
Now, Lord, on the previous.
Wait, I'll get back.
On the previous day, there was a submission made when I was reading the court commissioner's report, in which there was the link shown between DCP Ranu Sharma and ACP Tanveer.
Correct.
That the court commissioner's report was given in a sealed cover. I submitted to your lordship.
And they were telling it is not opened.
Yes, the learned senior had said it was not opened. But I'm producing the certified copy of the court commissioner's report and the order of the trial judge. But please see page 3 in that memo.
Received today sealed cover. In the presence of both the counsel, plaintiff and defendant, sealed cover is.
Sealed cover is hereby opened.
Was opened and kept in safe custody, my lord. It has not.
No. Sealed cover is opened in the open court. Upon its opening, it contains commissioner report with CD and invoice. Office is hereby the same in safe custody till for the defendant press.
Validity and the.
1 minute. Where is the certified copy application?
Certified copy is at page 28. It starts at page 4.
28, is it?
Page 4 it starts at.
Page 4.
Page 4.
Next page.
Okay. You'll get a note by city civil and sessions that stamp it.
Oh, this is the entire certified copy.
I've also
yes.
produced the typed copy now. I read out those.
Certified copy.
If I may produce a judgment of this coordinated
Sir,
bench of this. court,
Certified copy is given to him.
Lord, the legality and validity of this report has not yet been decided.
That's all
by the
right,
court.
certified copy is given to him.
Yes, my lord.
Then you said it's in safe custody, can't be taken by him.
said it was
Your
not
senior,
opened. He said it was not
first said it is not even opened. How did he get it? Now it is opened.
Yes, ma'am.
The court records it is opened. Now you say it is, it was to, 1 minute, it is to be kept in safe custody. Certified copy is given by the court itself. And where is the question of safe custody or not opened? Both the submissions are false.
My lord, the report, the validity and legality of the report.
Now you are in a third submission. That validity or legality is yet to be tested.
Primary
So first submission of sealed cover is false. Second submission of this being kept in safe custody and cannot be given is false. The third submission is now your,
Been kept in safe custody.
the certificate copy is given, sir. How did he get it? And they are telling.
My lord, from the safe custody, the trial court.
Trial court is granted. Safe certified copy given by the court. How, what fault can you find with him?
Lord, their entire basis for saying that a DCP interfered with the investigation and so on is based on this report
Sir,
My lord,
based
we
on
have-
the report of the court commissioner.
of the court commissioner.
Correct.
We have strong objections to this court commissioner. My lord, a court commissioner's report cannot be taken on its face value. It has to be subjected to adjudication.
Now,
and
1
based
minute,
on the evidence
1 minute, 1
before-
minute, 1 minute. What is your prayer?
Prayer is for transfer of this investigation to an SI.
How are you to be heard in the matter even?
My lord,
You are the accused.
I'm for
You are the accused. Accused has no say in a matter where investigation is to be transferred to any other independent agency.
My lord, that may be so, my lord.
That may be so, then you have to, then you have no audience.
The second prayer that is sought
What is second prayer?
is to carry out my arrest.
That's already done. It's become infructuous today.
Oh, that has
It is
been
an
made
incorrect
infructuous.
submission.
There
The
are
direction-
allegations.
One
given
minute, both of you
in
bad.
this petition.
Sorry?
Not only is the investigation sought to be transferred to the SIT,
All
but
right.
also allegations have been made against me.
So what?
Allegations have been made saying that over and above what is given in the complaint and the FIR,
So
there is
what?
threat to national security. So
That is for the purpose of constitution of SIT. Where are you in the picture?
Humble submission is,
Yes.
if any allegations have been made against me, I need to be given a right to object
No,
to the
no,
same, my
sir.
lord.
Not
for
at
the
this
constitution-
stage at all.
Not for the constitution of SIT.
No, no,
As
not at this stage at all. You forget about the allegations. Now, the plain and simple prayer is constitution of SIT on the investigating officer. See, things are very clear in this. 90 days, no arrest takes place. No anticipatory bail is granted. Anticipatory bail is rejected. Even then arrest does not take place. For
matter of 3 days. since
all
the
right, no
anticipatory
problem,
bail was-
no problem. So it is 93 days, no problem. 90 days, a person is roaming free without getting arrested, notwithstanding no protective orders anywhere. Deliberately, the arrest memo is converted into a 35(3) notice when it goes to Delhi to arrest. After the arrest, where is the question of 35(3)? All these creates such suspicion in the investigation that it should be handed over to an SIT.
My lord, the
Just
35(3)
please see
notice
page
itself
75, the
is
coordinated
dated on the
bench's
same
order.
day.
And in a petition seeking handing over of an investigation to the CBI, SIT or whatever, the accused need not be heard unless he himself makes them a party.
Lord, can I make one additional point? In their 482 petition which they filed, they themselves have made an allegation against the IO that the IO had demanded a 5 lakh bribe from A2.
Yes, ma'am.
So even they don't have
Correct.
confidence in this IO. In fact, they say that the IO was acting under my instructions. If he was acting under my instruction, the arrest should have happened on 25/12. For 90, I would not have to be forced to come to this court and ask for enforcement of his statutory duty to act under 41A4. 90, not even a second 41A notice issued. 90 days, no second 41A notice, only one 41A notice. And he defies his own order. He himself passes the order on 25/12 asking for the arrest.
There is-
He deputes a team.
There
He
is
knows that
much more than what meets the eye in this case.
Yes.
Absolutely.
Lord, if it may kindly be passed
Lord,
over.
just
my lord.
please see,
Senior
Lord,
shall
one
address
document.
arguments on this point.
Sorry?
My lord, if it's passed over, even we may be permitted to be heard in this.
Not the, in fact.
Only on the
No,
limited
sir.
part of the allegation.
I'll tell you one, allegation, you forget about the allegations. Now these allegations are qua the second prayer,
Yes.
that you are not arrested. Now that prayer itself is rendered infructuous in the light of your arrest and your remedy lying elsewhere after the arrest.
Yes, ma'am.
Now the what prayer remains in the case at hand is constitution of SIT prayer A. Ashte. Adik you need not be heard. Accused need not be heard. With settled law, sir. I was myself said. I have myself said so.
Well settled. Lord, just please see page 77.
The investigation material was
Page
called for.
75.
by this honorable court.
Allah,
At
the
least if
IO
I
has
may
not
be-
arrested himself, 90 days he has not done anything. A1's seized devices, ಅದು ಹೆಂಗ್ seize ಆಗಿತ್ತು ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಹಂಗೆ ಒಂದು ಕವರ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಸೈಡ್ ಅಲ್ಲಿ ಇಟ್ಟಿದ್ರು 90 days. Custodial interrogation was required. The man who was required to do the custodial interrogation himself gets arrested.
My lord, I have not gone
Demanding
through
a
this
bribe.
investigation report where it's kept in a seal, it's kept in a cover on the side. I have
Please
not
see
gone
what
through
the
this.
coordinate bench
If the
has said,
complainant is coming before this court and telling all the particulars of the investigation, my lord, at least I may be permitted. to
No,
go through
sir, you have no say at this stage. You, investigation time you will have all the opportunity.
My lord, investigation has gone on over the last 2 weeks since their arrest.
What has
investigation
gone on, we'll see.
And
Yes.
police have said no further interrogation is required.
Already,
In
After
5
a matter of
days,
6 days.
Already.
The
Yeah,
only
yeah.
where are the investigation papers?
One humble submission.
Huh.
Lordship may take up this matter tomorrow because I just received the report today because.
What
today is-
report?
No, they've sent a report.
What
because-
report?
No, there's some inconvenience because.
Inconvenient report.
Allala,
Huh?
there's some inconvenience because today is this police or March day, there's the police parade day. So
March
adrinda-
day, this is
Allala,
April.
Flag day.
Flag day.
So
All right.
adrinda, they just sent the
Allah,
report
just
and
please see
moreover,
75 one.
and moreover,
Just
the
please see
investigation
75.
officer was also not, he was
suspended,
not in
he's deemed suspended.
communication. Your Lordship may have this tomorrow. I'll make my, I'll
Just
make
please
my
see
submission.
So we will hear the state, but not you.
Yes.
Your Lordship may
In
hear me
a,
tomorrow.
because the second prayer, I will record that the second prayer today does not survive. And all the allegations are qua the second prayer, which would regarding arrest. First prayer we will consider.
But just please see 75.
Page,
On the previous day, I did not have the benefit of the coordinate bench's order dismissing their anticipatory bail. Please
page
remember, Lord.
75
page
is
Allah,
the
not
sessions court order.
Illa, 75 of the memo that I just produced.
Memo. Justice Nawaz's order.
How? 75 on top, the operations are set to be
75,
75.
one moment.
75 on the top note, operations are said to be governed by stringent confidentiality and security protocols, hence play a critical role in national security. Therefore, any unauthorized divulgence can have serious repercussions. It cannot be said that there is no prima facie case. Granting pre-arrest bail can significantly hamper the investigation, particularly in collecting useful information and uncovering concealed materials. Courts must exercise caution when granting anticipatory bail, especially in cyber economic crimes. Custodial interrogation is necessary due to the technical nature of the crime and to reveal the full extent of data theft and its concealment methods. Petitioners' actions show their ability and willingness to destroy and tamper with evidence. Preliminary findings will establish that petitioners continue to access, retain, and use proprietary information even after their resignation, and demonstrates a deliberate attempt to misappropriate data for unlawful benefits, constituting a prima facie case. After this order, they approached the 482 court because here there was a direction to go and arrest and custodially interrogate. He still does not act. There's a legitimate expectation.
What happened before the 482 court?
Please see the next page, Lord. The order sheet is produced. 19.3 Bharat. This order is passed, which I just read. Justice Nawaz's order comes on 18.3. 19.3, they move the 482 court. 21.3, please see what the order sheet says. They argue, but no interim order has been passed.
So there is no stay.
There is no stay, it has been refused. Then on the next day, 25.3, your lordship passes the previous order. They go before the 482 court and ask for an adjournment for another 2 weeks.
No, Lordship, here, we have seized the mobiles and laptops and it has been sent for forensic report. That's what the report says.
Where is the IO?
No, I may be.
Where is the IO?
No, Your
IO
Lordship.
himself is caught red-handed as taking bribe
Your Lordship may give an opportunity.
and is arrested.
No, sir, I'll make my submissions tomorrow.
Our information is the 482 court, after 2 days of his arrest, caught red-handed accepting a bribe, has been granted bail in the 482 court. He's out on bail.
Your Lordship may have this matter tomorrow. I'll make necessary
When
submissions.
grounds of arrest, huh?
Grounds of arrest,
Allala, yeah.
grounds of arrest, kottila anta order al bandu.
Your Lordship.
Well, that's the
I've
only way 482 court can grant
That
bail.
friend has got.
It's a public document.
Allala, public document.
Magistrate.
No, Your Lordship may have this matter tomorrow. I'll make necessary.
Just please see one page, Lord, page 79. Now, I've pleaded these facts as well in my writ petition. 79 ali, 18% is the charge sheet filing rate. I've retrieved this data from the State Crime Records Bureau. I've used an AI tool to produce it in a graphic form.
Hmm.
18% is the charge sheet filing rate.
Hmm.
Just please see the next page. The number of crimes that have happened from 21 to 23, it's almost a twofold increase every year.
No, this is in public domain.
It's in public domain. 3,500 crore of money has been lost to cybercrime in the last 5 years. Just last year, 2,000 crore has been lost. And Lord, the most shocking aspect is in this year's Karnataka budget, 5 crore has been allocated for increasing the technical capabilities of our cybercrime teams.
Whose technical capabilities? Who is technically capable here?
Lord, these are all conventional crime investigators. Or Arthane Aktila, adike 18% charge sheet filing. The learned magistrate before whom the bail hearings are going on is lamenting. It's not even 18, he says. It's 2%. He laments
Let's
that
see.
the entire system is collapsing.
Yes.
He
So
says,
your
I don't
lordship,
have the power. I don't have the power because I'm just a magistrate.
Let's see.
Something
I'll
has to
place
be
the
done,
report
Lord.
tomorrow,
There's
Your
an
You,
urgent requirement for
You
reform.
file a list of dates and events and synopsis.
Already ready them, Lord. I'll just pass it on.
Yes.
Your lordship, I'll place the report tomorrow, your
My
lordship.
written submissions and my list
Could
of
you-
dates I'm
yes.
submitting.
Who's
Already served a
investigating
copy
them?
on that.
Served a copy?
Served a copy
Yes.
on both.
So in the first prayer, you need not be heard. The petitioner heard counsel Angad Kamath, learned counsel Rahul Karyappa and counsel so and so. The petitioner has sought two prayers. The second prayer was with regard to taking the accused into custody, which had not happened for over 93 days after the registration of the crime in the aforesaid, for the said offences. This court on first order yavattu? On 23/20/25 had passed the following order. And again on 25/3/2025, the following order. It transpires that on the next day, 26/3/2025, the accused have been taken into custody. Therefore, the second prayer that is sought with regard to the custody of the accused has is rendered unnecessary today in the light of the event happening. What remains is the first prayer. The first prayer is to constitute a special investigation team to investigate into the cyber crime, the alleged cyber crime in the case at hand. The learned counsel for the petitioner, Angad Kamath, has produced material along with a memo with regard to the necessity of constitution of a special investigation team in the case at hand. The learned counsel appearing for the respondent submits that he be heard in the matter. It is trite law that an accused would not get audience in a case where the matter is considered for transfer of investigation to any independent agency. As the apex court and plethora of judgments has considered this issue and set the controversy to rest with regard to the audience of the accused at the time of transfer of investigation to an independent agency, unless the complainant himself would make them a party in the proceedings. The complainant has not made them a party in these proceedings and is not necessary to be heard. Therefore, the learned list this matter day after tomorrow in the fresh matters list to hear the state on as to why the matter should not be transferred, matter should not be laid before a special investigation team as is sought by the petitioner. Day after tomorrow. Yes. Parole.
Your lordship,
Yenidu?
This petition
Parole.
for release on parole, trying for release on parole.
Your
What
lordship,
offense?
For a term of 90
you have
days.
concealed the fact.
Ah,
Yeah, 10 times he was granted general parole and 4 times emergency parole.
ah.
Last parole was granted on 27/11/24 and he has surrendered on 24/2/2025.
24 to 25.
24/2/2025.
ಕೂಲಿಂಗ್ ಆಫ್ ಪೀರಿಯಡ್ ಇದೆಯಲ್ಲ 6 months.
ಅದೇ ಇದು ಆಗಿಲ್ಲ.
ಅಲ್ಲ ಯಾವ ಕ್ಲಾಸ್ ಅದು ಕೊಡಿ.
Your lordship.
ಎಸ್.
Now that puts.
Here, your lordship, his mother is under serious condition.
ಅದಕ್ಕೆ 13 ಸರ್ತಿ ಹೋಗಿ ಬಂದಿದ್ದೀರಾ.
ಹಂಗಿದ್ರುನು.
You are more outside than
Not
inside.
for general parole.
M is recommended for permanent remission.
ಅದು ಬರ್ಲಿ. ರೆಕಮೆಂಡ್ ಆಗಿದ್ಯಾ?
14 years, 11
ಎಲ್ಲಿದೆ? Where is the recommendation? Where is the recommendation?
All originals, medical records brought here. He has not produced any document.
Imprisonment certificate illa,
ಏನಿಲ್ಲ sir.
ಏನilla.
And he has also not, his,
Secure a
Consider-
report, complete report. The learned AGA is directed to secure a complete report of the submission that the petitioner's name has been recommended by the advisory board for premature release. List the matter on 15th, yes. The fresh matters list. Next. An offense? 302. 376. POCSO. ಆಮೇಲೆ
no, not premature
recommended for
release.
premature release.
ಮಾಡಿಲ್ಲ, first, no, he has not gone on parole. General.
First time,
First time. ಅದು premature release ಅಂತ ಹೇಳಕ್ ಹೋಗ್ಬೇಡಿ. Eligible ನಾವು ಇನ್ನು ಮಾಡಿಲ್ಲ.
Yes, we will grant 30 days.
ಆಯ್ತು.
Subject to liberty. Yes. First time parole.
First time.
The petitioner is before this, he is the convict himself?
No, brother.
The brother of the petitioner, the brother of the convict is at the doors of this, daughter anta ide, brother anta. ಏನಾದ್ರೂ ಒಂದು ಹೇಳ್ಬಿಡೋದು. The sister of the convict is before this court seeking release of her brother on parole. Heard so and so. The petitioner, the brother of the petitioner gets embroiled in a crime for offences punishable under section 376 2G para 2 alide alla, and is tried in SC 487 of 2013. The petitioner gets convicted of the offence and is now in prison for the last 11 years, 3 months and 14 days. 3 months and 14 days. The petitioner submits that he is eligible to be considered for premature release. Be that as it may, the learned counsel, what merits acceptance is the submission of the learned counsel for the petitioner that the petitioner is seeking parole for the first time in the last 12 years. First time in the last 12 years. Reason? 12 years, and the imprisonment certificate appended to the petition does not demonstrate any adverse entries against the petitioner in the jail. In that light, I deem it appropriate to grant the petitioner parole for a period of 60 days to become operational from Saturday. Yes. Next.
What's the challenges to the proceedings essentially under section 3(2) of the KPID Act?
Where is Viresh Budhyal?
Will the matter be taken up tomorrow?
Why tomorrow?
It's,
First
very
time
short.
ಬರ್ತಾ ಇರೋದಲ್ಲ.
No, it's for the second time, it's coming up. Of course, after. his
ಇಲ್ಲೇನೋ
appearance.
ಫಸ್ಟ್ ಟೈಮ್ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಬಂತು.
We filed a statement.
Office objection. Statement
Yes, they have already filed a statement of objections, my lords.
Where is it? Preliminary statement of objections. We'll take it in preliminary hearing tomorrow. Yes.
Fresh matters, let it be, because my lords, the issue is only this, my lords.
Fetch matters let ಸುಮ್ಮನೆ ಹೇಳಿ.
They are not proceeding
List-
against this person,
list
but his
mat-
properties is attached. That's the only question.
Heard the learned senior counsel, D.R. Ravishankar appearing for the petitioner at the request of counsel Viresh Budhyal list this matter tomorrow.
What's 103 is also, my lords, in relation to the same notification.
Tag the petition along with 103.
Please.
Yes.
32.
5 lakhs release.
Yesterday, your lordship directed.
ಆಗಿದ್ಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ, ಅದು amount ಆಗಿದೆ. Now the issue what they are facing is the patient is under coma, the parents want to
Oh,
release. the
correct,
amount.
correct. ಅದರದಲ್ಲ.
So your lordship requested.
50 lakhs release ಆಗಿರ್ಬೋದು.
5 lakhs.
5 lakhs ಅಲ್ಲ.
From the chief.
Affidavit ನೋಡಿದ್ರಾ?
ನೋಡಿದೆ ನಾನು.
ಹಾ.
That they have undertaken that they'll take care. They are the parents.
Will, yes. The petitioners are before this court seeking the following prayer. The petitioners are, heard so and so. The petitioners are parents of one Vijay Kumar who meets with a road traffic accident in the year 2021, resulting in severe head injury. It transpires that the son is now in coma, na? Son is now in coma. The petitioners had approached the chief minister requesting financial assistance and the office of the chief minister considering the request as approved, grant of rupees 5 lakhs. That is transferred to the respondent, second respondent, Karnataka Gramina Bank. The bank is not, the bank has not transmitted the same to the account of the petitioners on the ground that the amount is released in favor of one Vijay Kumar, and since Vijay Kumar is in coma, the petitioners would not release it in favor, the bank would not release it in favor of the petitioners. This court directed the petitioners to file an affidavit of undertaking that they would spend the amount only on their son. The affidavit reads as follows: in the light of the affidavit so filed, I deem it appropriate to direct the bank to release the fund of 5 lakhs that has come to the account, come to its account in favor of these petitioners, with the aforesaid these petitioners without broking any delay within 1 week from the date of receipt of the copy of the order. With the aforesaid observations, petition stands disposed. Yes, next.
33.
First time, huh? Copy kodi. The counsel for the petitioner is directed to serve set of papers upon the learned AG, place the matter on Monday in the fresh matters list. Next.
34.
Extension. Bomb blast alla tane. Where is the order granting parole? My order? Yes, Hemant Chindan order. But petition is before this court. This court, the coordinate bench of this court had granted parole by the following order. The subject petition is preferred, seeking its extension. Seeking its extension. The parole that is granted to the petitioner, which comes to an end on 6/4/2025, stands extended for another 60 days from 60 days from the date of its expiry. Ordered according. Disposed. Next.
35.
Royalty covered. Kudi or nenne kottala same. Disposed. Same order. Next. Yes, Mahesh.
36.
I pay for the respondent bank.
The interim order was to deposit 50 lakhs. I deposited 1 crore. And your lordships, my lord.
Page 65. Yes.
And there are some order that they shall consider the regularization. And now, my lord, even during the.
Our L consider ಮಾಡ್ತಾರೆ ಏನು madam? Yes, sir.
My lords, the order was passed on 5th, my lords.
Yes, sir.
The sale notice is issued on 15th.
Yes.
He gives a representation on 19th.
All
On
right.
21st, we give a reply, my lord, saying, come to the bank and settle and let us discuss.
Come to the bank.
Yes, come to the branch to
Go
discuss
to the
this.
bank.
My lords, I'll just submit. That email he does not produce. He suppresses that email.
All
He
right.
just-
Now, your egos are hurt.
Not equal, my lords. Then, my lords, the lordship directed them to come to the bank and see if there is a possibility of any regularization, my lords. He has visited the bank. The bank is not able to regularize the overdraft account, my lords, for 3 reasons. His GST, my lord, there are GST dues and it has been deactivated since the last 2 years. And there is no fresh work order. This is a overdraft facility. So there is no fresh work order.
Yes,
So-
Mahesh. ಅವ್ರು ಕೊಡಿ. ಕೋರ್ಟ್ ಕೊಡೋದಲ್ಲ, ಬ್ಯಾಂಕ್ ಕೊಡಿ. Give it to the bank. Look into it.
There are 2 fresh overdraft.
Place the matter on 16th in the fresh matters list. The learned counsel for the respondent bank submits that the overdraft account cannot be regularized for twin reasons. One, the petitioner does not have any work order today, and the other, the GST dues are not cleared. While the non-clearance of GST dues cannot be the botheration of the respondent bank, work orders would become imperative for the reason that overdraft facility was granted only on the strength of the work orders. The learned counsel for the petitioner submits that there are 2 subsisting work orders in favor of the petitioner and seeks to place them on record. The bank shall consider the same and consider regularization of the account of the petitioner on the score that the petitioner has already paid 1 crore as observed in the earlier order. List the matter on 16th, 16th in the fresh matters. Interim order subsisting will continue to the next.
No interim order, my lord.
The respondent shall not precipitate the matter till
The
the next
sale
date.
notice auction is on 5th, 11 crores, my lord. They just paid 1 crores, 11 crores is the
Will
outstanding.
direct. ಈಗ ನೆಕ್ಸ್ಟ್ ಪೇಮೆಂಟ್ ಯಾವಾಗ? ಸೇಲ್ ಸ್ಟೇ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಪೇಮೆಂಟ್ ಬೇಕು. One more crore.
May make one, sale confirmation may be stayed. Again, it's a, let him pay, subject to that sale confirmation may be stayed.
The learned counsel for the petitioner submits that the property is put to auction and the auction is slated to be held on 4/4/2025. The dues according to the,
11 crores, 11 lakhs, my lord.
ಓಡಿ ಎಷ್ಟು ತಗೊಂಡಿದ್ರು ಸರ್?
My lord, 4 crores was the initial OD. It's
All
there
right.
in the demand notice. They have
Total
put-
ಓಡಿ ಎಷ್ಟು?
My lords, there are 4-5 credit facilities apart from the OD. It's at page number 51, my lord. There are 5 credit
ಮಹೇಶ್,
facilities.
11 crores ಕರೆಕ್ಟಾ?
ಹೌದು.
That's all right. Now 1 minute. Deposit 1 crore in the next 3 weeks. Will stay the sale. The sale that is slated to be held on Friday shall remain stayed subject to the condition that the petitioner would deposit 1 crore with the bank on or before the 23rd of April 2020. No, on that day we'll grant 23rd April 2025. They list this matter on 24th April 2025. In the event the deposit as directed is not made, the same order is.
My lords, the petition itself becomes infructuous, my
Why?
lord. Because if sale does not take place, my lord, then this petition becomes infructuous.
No problem. You will
Let
issue
him at
another
least deposit
notice.
30%, my lord. 11
Wait,
lakhs
wait.
sale notice is there.
Wait, sir. We'll do it. Yes.
My lords, the earlier round also you had interim order for almost 8 months, my lords. Only 1 crore he has paid. This is the second writ petition, my lords.
Will pay. We'll direct him to pay. After 23rd, again I will direct one.
Petition on your
Three-
sale
three-
ಆಗಿಲ್ಲ ಅಂದ್ರೆ your lords is my
ಒಂದ್ ನಿಮಿಷ
dispose.
ಸರ್. ನಿಮಗೆ ಏನ್ ಬೇಕು?
ಅಲ್ಲ, at least
ನಿಮಗೆ ಏನ್
30%
ಬೇಕು?
let him
ಒಂದ್
be
ನಿಮಿಷ.
directed.
ನಿಮಗೆ
is my
ದುಡ್ಡು ತಾನೇ
submission.
ಬೇಕು?
ಹೌದು sir. Let him
ಈಗ
pay 30%. Last 8 months he has
30%
not paid. 1
ಒಂದೇ
crore
ಸರಿ.
40. 100 ಕೋಟಿ dues ಇರೋದು 1
We
crore
will
30.
direct all
Every
that.
time they file a writ and this is the second writ, my lords.
No problem. Sir. Yes.
Last month it was disposed, one more writ and again interim order, again for 6-8 months it will be pending here, my lord.
What
That
to
is
do?
the reason.
Sale does not take place ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ?
My lord.
We will dispose it as infructuous. Now this time I will not dispose it as infructuous even if the sale does not take place till he complies with it. Yes. List on 24th. ನಿಮಗೆ ಬೇಕಾಗಿರೋ ದುಡ್ಡು ತಗೊಳ್ಳಿ.
ಅದು ಇನ್ನೂ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಡ್ಲಿ.
ಇನ್ನೂ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ.
30% ಕೊಟ್ರೆ it will
ಪರವಾಗಿಲ್ಲ,
be-
ಕೊಡ್ತಾರೆ.
even DRT
ಈಗ
direct 30%.
10% ಆಯ್ತು. We'll direct in 10%. Yes.
I filed the wakalat today morning.
ಎಷ್ಟಿದೆ ಸರ್? 7 lakhs.
7 crores, 7 crores.
7 crores ಏನು 2 0 ತೆಗೆದೇ ಬಿಟ್ರಿ. ನೋ ಸರ್, 7 ಸೇಲ್ ಇದೆಯಾ? ಸೇಲ್ ಆಗಿದ್ರೆ ಏನಾಗಲ್ಲ. 7 ಕೋಟಿ ನೀವೇನ್ ಕಟ್ಟಲ್ಲ ಬಿಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಕಟ್ಟಲ್ಲ because 5 notices have been issued. This is the 5th notice.
ನೀವೇನ್ ಕಟ್ಟಲ್ಲ. ಕಟ್ಟೋದೆ. ಪೇ ಮಾಡಿ ಬನ್ನಿ, ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಡ್ತೀನಿ ಆಮೇಲೆ. ಆಯ್ತು. List this matter on 17th April. The learned counsel for the petitioner submits by the said date 2 crores would be paid. In the event 2 crores is paid, interim order or interim protection would be granted on that date. Yes. Next. Parole.
Emergency parole.
Emergency parole.
138, convicted under the section 138 of
38 of
Negotiable
NI.
Instrument Act.
Yes. The petitioner is before this court.
So he's served only 4 months. The emergency ಹಾಕೊಂಡಿದ್ದೀವಿ.
ಎಷ್ಟು ಎಮರ್ಜೆನ್ಸಿ ಪರೋಲ್?
ಅದೇ 4 months 4 months ಆಗಿ.
ಪರವಾಗಿಲ್ಲ. 138 ಅಲ್ಲ. The petitioner is before this court seeking the following prayer. The petitioner gets convicted of offense punishable under section 138 of the Negotiable Instruments Act and is directed to undergo imprisonment for a period of 1 year. The petitioner has completed 4 months in prison and has preferred an application seeking release on emergency parole as reason
To undergo vascular surgery. Malad, the chief
to
medical
undergo surgery. The petitioner has produced the documents. The petitioner has appended the documents to the petition to demonstrate that the petitioner has to undergo surgery immediately. In that light, I deem it appropriate to grant the petitioner emergency parole for a period of 15 days to become operational from, operational from tomorrow. Yes.
Please. 30 if necessary, my lords, to seek an extension.
Reserving liberty, ಕೊನೆಗೆ. Yes, next.
Please.
39, 380 allowed. Section 380 theft.
No, the case
Theft.
pending again.
One,
ಏನ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ?
one case 380, same case pending, one case ಇದೆ your lordship. 3 years.
ಎಷ್ಟನೇ ಪೆರೋಲ್?
First,
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
3 years ಆಗಿದೆ your lordship. 7 years.
3 years ಆಗಿದೆಯಾ? 7 years imprisonment.
Yes, your lordship.
But your lordship here, seeking for 90 days, not an emergency parole, since one case is pending.
ಏನ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್? 380.
380 your lordship.
ಇದು 302 ನಾ?
ಇಲ್ಲ your lordship, 380.
ಇದು 304.
380
Yes,
pending.
30 days will grant.
Right.
The petitioner is before this court seeking the following prayer. Heard so and so. Madam, drill ಗೊತ್ತಲ್ಲ.
With liberty your lordship.
Liberty bed.
With liberty.
Yes. Next.
Emergency parole, my lords.
Yes. ಇದು ಪರವಲ್ಲ?
Please, my lords. Emergency parole.
Same order of, ಇದು 138.
No, my lords, this is 376.
376.
ಏನು ಇದ್ರಲ್ಲಿ ಎಮರ್ಜೆನ್ಸಿ ಏನಾಗಿದೆ?
Diffuse symmetrical disc bulge ಅಂತ the chief medical officer has given a report.
Of the jail itself.
Jail.
Yes. The petitioner is before this court. You are the convict yourself?
Please, my lords.
The petitioner, the convict is before this court seeking release or seeking his release on grant of parole on the ground of medical emergency. The petitioner gets convicted of the offense under section 376 of the IPC in SC 309 of 2012 and has been in custody since 2012. The petitioner has, as on today, been in prison for?
My lords, he was released, my lords, he was arrested on 13/7/12 and was released on 12/12/2012.
For 9 months now.
9 months.
For 9 months now, after his release in the year 2012, the petitioner seeks grant of emergency parole owing to an acute medical condition. The medical condition is assessed by the chief medical officer of the prison itself. In that light, I deem it appropriate to grant the petitioner emergency parole for the period of 15 days, subject with reserving liberty to seeking its extension to become operational from tomorrow. Day after tomorrow. Yes.
Please.
Next.
41.
Passport has been applied. The
Applied.
PCR is referred for investigation of section 156(3), which is a violation of.
Lord, he is entitled for full validity passport. However, my lord, if your lordship may have it on Friday, my lord.
ಕೊಟ್ಟೆ ಬಿಡಿ.
Illa. Your lordship may have it on Friday. It's only a PCR, my lord.
Friday will grant
August.
complete validity passport. Yes. Yes. List on Friday. Registry to print the name of Shanti Bhushan is appearing for DSGI. Shanti Bhushan is appearing for this Union of India. Appearing for the respondents.
Hello.
Next.
42 and 43.
This is,
Compensation.
this is, my lord, your lordships recollect that BWSSB case where your lordships quashed various charges. That order was passed on 5th of April, wherein one of the charges your lordships quashed was this beneficiary contribution charge.
BCC.
Correct. That was on the ground that 110 villages were merged into
Correct.
Bangalore city.
Correct.
Now, my lords, they changed from BCC to ETP. Now there is ETP.
New nomenclature.
New nomenclature. Same and same 110. In fact, kindly see the date of your lordship's order is 5/4/24. The impugned resolution is on 9/7/24.
Page.
33. Page 33.
Ah.
My lords, may kindly see page 35, last paragraph. ಮೇಲಿನ ಎಲ್ಲ ಅಂಶಗಳನ್ನು. Same reason. 110 ಹಳ್ಳಿಗಳ ಎರಡನೇ ಹಂತದ ಯೋಜನೆಗೆ so and so. Same reason. So nomenclature.
ಅಲ್ಲಿ ಸ್ಟೇ ಸಿಗ್ಲಿಲ್ಲ ಅಂತ ಚೇಂಜ್ ಅಷ್ಟೇ.
And now, my lords, what is happening is, my lord, this is the judicial cooperative housing. This is in that towards Kanakpura side. My lord.
All right.
There are water connections are not being given on the basis of this impugned resolution. Kindly see there's another communication at page 40.
किससे पंगा लिया? Yes.
Now, my lord, I'm told, my lord, they're relying on bore wells. How long will these bore wells last?
That's all right. That's a different thing. we are on the legality.
Legal issue, but the dates are. That's what I
Heard
want.
the learned senior counsel Sri Vikram Holygold appearing for the petitioner. The issue in the list revolves around demand of certain charges by the BWSSB to be paid prior to getting water connections to the respective buildings. Earlier, the charge was, the impost was named,
Beneficiary contribution charges.
beneficiary capital contribution charges. This court, in terms of its order dated 5th April 2024, set aside the charge, the impost of the beneficiary contribution, beneficiary so-and-so charges on the score that it lacked power to do so, and there was no reason to do so. Now comes the same charge in a new avatar. The nomenclature is changed and the charge is the same. The nomenclature now is what is ETP?
ETP full form, establishment of tools and plants.
Establishment of?
Tools and plants.
Now in the new nomenclature, now it is ETP, establishment of tools and plants. While the impost is the same, the reason is the same. In that light, the resolution of the BWSSB appears to have been resolved to get over the order passed by this court, which would fringe on the borders of contempt unless the order is set aside by a superior fora. In that light, there shall be an interim order of stay as prayed for. Next, one respondent state, one AGA, BWSSB party.
Yes,
Learned Counsel BL Sanjeev is directed to accept notice for the respondents. Next. Why is registration of sale? Jafar.
This matter, my lord, there is no endorsement issued specifically saying that they have denied. He is relying upon a letter that he has issued. There are two civil suits that are pending by either of the parties.
Civil suit pending iದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ? Registration ಮಾಡಲ್ಲ ಅಂತ. ಮತ್ತೆ?
I will secure instructions in this matter.
Yes.
And then we will.
Orders are, my lords, vacated.
That is
Civil suit ಅಲ್ಲಿ.
Civil suit.
Interim orders are vacated.
Where
Those-
see?
No, both rival parties.
Learned
have filed
AGA is directed to secure instructions with regard to the prayers of the petitioner and make his submissions on the next date of hearing. ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
Yes. List the matter on 15th in the fresh matters list.
Interim order vacate ಆಗಿರೋದು ಒಂದು order.
ಆಯ್ತು ಕೊಡಿ. Place it along. Yes, next. Police protection. ಅದೇ ಅಲ್ವಾ? Yes. Not sought for?
No, they've not sought any requisition or anything seeking police protection.
Representative ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, representation ಕೊಟ್ಟಿಲ್ಲ.
My lord, show my lord.
Representation ಕೊಟ್ರೆ ಅದ್ ನೋಡಿ ಕನ್ಸಿಡರ್ ಮಾಡ್ತೀವಿ.
Page.
Your lordship may kindly turn to my lord the annexure B.
That was earlier.
My lord, for a minute, my lord, I will.
Wait, Ram.
Friend looks to be very enthusiastic about this matter.
No, it is necessary, sir.
Yes, yes, very good.
Yes.
My lord, page 26, annexure B.
Yes.
My lord. Now, my lord, we had sought for, my lord, the assistant commissioner, my lord, sought for police protection to be, for the Jatra to be conducted on 9/3/25 to 11/3/2025. Now, my lord, this Jatra, my lord, which was supposed to be held on 9/3/2025, could not be held because, my lord, there was some dispute between two other factions which we have nothing to do with, because we are the managing committee appointed for this purpose for the last 3 years. Now, my lord, page 30, my lord, is the order where the assistant commissioner, that is the second respondent, clarifies that the suit which is between two parties will not come in the way of this Jatra to be conducted.
When does that spring?
My lord, this is, my lord, on 7/3/2025.
Oh, that is annexure C.
Yes, my lord.
All right.
So he gives a clarification, it can go on. Though, my lord, a clarification is given, the police, my lord, I'm sorry, my lord, the Tahsildar says a prohibitory order has been enforced, saying that there is a dispute between two groups. Therefore, my lord, though there was a request made by the second respondent, assistant commissioner, to give police protection, he, my lord, as per annexure, my lord, page 35.
Page?
35. The lordship kindly turn to page 36. Prohibitory orders are enforced from 11/3/2025 to 14/3/2025.
ಅದು ಆಗೋಯ್ತಲ್ಲ?
ಆಗೋಗಿದೆ. Now, my lord, subsequently, now the Jatra is on 5/4/2025. Therefore, my lord, we are seeking for police protection.
Yes, sir. ಇವ್ರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟು ನೀವು ಅದಕ್ಕೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಜಾತ್ರೆ ಆಗೋಗಿರುತ್ತೆ. Yes, heard the learned counsel, petitioner is before this court seeking the following prayer. ಇದು ನೇಮೋತ್ಸವನಾ? Yes. ನೇಮೋತ್ಸವ.
It is by the managing committee appointed by the second respondent. It is not that, my lord, we are not rival factions. My friend has to be, my lord, supportive to us rather than, my lord,
I have to support.
ಅದಕ್ಕೆ no, you mistook him. He is excited to support you. Yes. The petitioners are before so and so are before this court seeking the following prayer. The heard the learned counsel Bipin Hegde appearing for the petitioner and learned AGA for the state. The issue in the list is with regard to grant of police protection at the time when the Harike Nemotsavala.
yes, my lord.
Harike Nemotsava would take place in the, which temple is this?
My lord, Kallamallige Ishta Devate.
ಎಲ್ಲಿದೆ ಅದು?
My lord, in the first petitioner, my lord.
In the so and so temple, constantly first petitioner. Correct. So on. The learned counsel, the said Nemotsava was initially to be held between 5/3/2025 to 11/3/2025.
9/3, my lord.
9/3, 9/3/2025 to 11/3/2025, for which purpose the petitioners had submitted a representation for grant of police protection during the said period, i.e. between 9/3 to 11/3/2025. The name Harike Nemotsava could not be held on the said date, on the said dates, owing to a dispute between the members of the committee.
Two rival groups, my lord.
Two rival groups in the committee.
Not in the community, in the
ಮತ್ತೆ
village.
ಇನ್ನೆಲ್ಲಿ?
In the village, not in
Two
the.
rival groups in the village where the temple is situated. The dates are now between 5/4/2025 to 8,
My lord, from 3/4/25, tomorrow.
3/4/2025 to 5/4/2025. And the petitioners are before this court seeking police protection for peaceful conduct of Harike Nemotsava in the aforesaid temple. The learned AGA would submit that no representation is submitted before the jurisdictional police for grant of police protection. And therefore, if a representation is today submitted, it would be considered and police protection would be granted by the state. The said submission is noted only to be rejected, as the Harike Nemotsava is set to commence from tomorrow, and the representation being submitted today and it being considered is unheard of in the annals of the government. Therefore, the present petition be treated as a representation. It's treated as a representation, but to the representation by the jurisdictional police. And the Harike Nemotsava that is set to be conducted, they're set to be held beginning from 3/4/2025 through 5/4/2025 shall be peacefully held with the support of adequate police protection. It is made clear any untoward incident happens, the responsibility would be on the jurisdictional police for inadequate police protection. Therefore, for the aforesaid reasons, the following order, the petition is allowed mandamus issues to the jurisdictional police to provide police protection during the period of Harike Nemotsava to commence, which is set to commence from tomorrow, 3/4/2025 through 5/4/2025 in accordance with law, ordered accordingly.
My friend informed the police, my lord, order copies.
Now, see, that's why you need excitement. Yes. Yes. Now he will inform. Yes.
Operative portion, my lord, if I may.
That will upload right away. Yes.
Oblige.
ತಗೊಳ್ಳಿ, ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ.
Number 127.
ಮಂಡ್ಗಿ ಸರ್, ಅದೇನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ನನ್ನ ಪಾಸ್ಪೋರ್ಟ್.
Passport, my lord, because they have to
Yes,
also
yes.
go for medical treatment.
Yes, yes.
Next week, my lord. I've requested my friend to see that they get it by next week, my lord. So he said he'll do.
Passport,
ಹೌದು, ಕೊಡ್ತಾರಂತ.
when he is there, you
No,
need not
I
worry.
see
Yes.
that, my lord. So
Absolutely.
very comfortable. He's not
Idre
made up his mind to
ಕೊಡ್ಬೇಕು.
fight for everything.
He has a record, sir, of getting the passport in 60 seconds ಅಂದ್ರೆ 1 minute,
16 minutes.
60 minutes, sorry, 1 hour.
Hats off to.
His record of getting it in 1 hour, so he will get it 1 week ತುಂಬಾ ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಅದೇ.
ಈಗ ಏನ್ will not pass any order or what?
Your lordship may pass.
Kindly pass on.
The
Covered by
Santosh,
Sharat Chandrasekhar, 18066 of 23.
page ಕೊಡಿ ಯಾವ್ದು?
But Sharat Chandrasekhar, my lord.
ಶರತ್ ಚಂದ್ರಶೇಖರ್,
Please.
that is short validity passport.
No, my lord.
Regular
FIR.
FIR stage ಅಲ್ಲಿ ಇದೆಯಾ?
FIR stage.
ಇದು ನಿಜ FIR stage ಅಲ್ಲಿ ಇರೋ ಮ್ಯಾಟರ್ ಅದು. ಎಸ್, ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ. The
Writ
petitioner,
18066 of 23.
the petitioner is before this court.
Petitioners.
Petitioners are before this court calling in question proceedings in crime number 115 of 2023, registered for offences punishable under section 448, 506 and read with 34 of the IPC. The heard the learned senior counsel Shri Anant Mandagi appearing for the petitioner and the learned DSGI Shanti Bhushan and counsel Shri Madhusudan Rao representing the complainant. The issue in the list does not issue in the list at this juncture does not relate to the merit of the matter. The petitioner is wanting to travel beyond the shores of this nation for medical treatment, for which purpose the passport would be required. Renew ಮಾಡಬೇಕಾ ಇದು? Expire ಆಗಿದೆಯಾ?
Renewal.
For which purpose the passport, which purpose reissuance of the passport/renewal of the passport would be required. In the light of the circumstance that is projected before this court, as also the petition, the FIR being still at the stage of investigation, the issue stands answered by this court in the case of so and so ಬರ್ಕೊಂಡಿದ್ರಲ್ಲ, wherein this court has held as follows. This court has, in this aforesaid judgment, has followed the circular of the ಅದೇ ಅಲ್ವಾ 10/10/2019, has followed the official memorandum of issued by the Ministry of External Affairs dated 10/10/2019, where the respondent themselves would observe that if a proceeding is still at the stage of investigation, a person would get a normal validity passport. In that light, the passport authorities shall not deny a passport to the deny renewal/reissuance of the passport to the petitioner without broking any delay. The learned counsel, learned DSGI Shanti Bhushan, as always submits that the passport would be will be issued in the next 1 week to the petitioner. The submission is placed on record. In that light, the petition and disposal alla. In that light, the order on IA. In that light, the application stands allowed to the aforesaid effect.
And it may be posted any day for argument. It is just
This is before me, is it?
Yes, my lord. Your lordship, sir.
Further here.
Further here.
List the matter on 17th.
Highly
Yes.
Highly obliged.
Yes. Yes, continue the list. Parole, KPID.
This is emergency parole, my lord.
Huh? ಆಯ್ತು. List the matter on Monday in the fresh matters list.
Not my lord.
KPID, sir, difficult.
Friday, my lord.
ಕೊಡಂಗಿದ್ರೆ ಅವತ್ತೇ ಕೊಡ್ತಾ ಇದ್ದ.
Emergency, she is bedridden.
Emergency?
Yes, my lord.
Bedridden ಅನ್ನ?
Yes, my lord. Her petitioner mother, my lord.
Mother. ಆಯ್ತು, Friday.
Friday.
Yes.
47.
For the petitioner, Your Honor.
ಆಮೇಲೆ
Proceedings under section 35 Advocates Act has been initiated against me, Your Honor.
correct.
The short submission is, Your Honor, on the same alleged facts dated 31/5/24, the respondent number 2 is filing multiple complaints, Your Honor.
Respondent number 2.
Respondent number 2, who's a professor in prestigious institution called NUJS. An FIR is also lodged on this complaint, Your Honor. And the matter was,
what is the allegation against you?
he's saying that I've told him that he's a monkey, donkey, and
Donkey? ಯಾವ ಚಿಕ್ಕ ಹುಡುಗರು ಇರ್ತಾರೆ ಡಾಂಕಿ ಮಂಕಿ ಎಲ್ಲ ಅನ್ಕೊಂಡು.
that's the complaint, Your Honor.
Where is the complaint?
The complaint is at annexure B, Your Honor, at page number 18.
threatened me with vulgar language by calling me monkey, donkey.
This is the same based on this, an FIR is filed, 155(2) is not complied, and there are other flaws also, but the court was pleased to grant the stay on that FIR, Your Honor. Even then, he has filed a complaint before KSPC and also Mysore Bar Association.
Mysore
Bar Association.
ಯಾಕೆ ನೀವು ಮೈಸೂರಿನವರ?
ನಾವು ಮೈಸೂರು, ಪೆಟಿಷನರು ಮೈಸೂರಿನವರೇ ಸ್ವಾಮಿ.
ನೀವು ನಿಮ್ಮನ್ನು ಕೇಳಿಲ್ಲ ಸರ್, ಪೆಟಿಷನರ್ ಕಂಪ್ಲೇನೆಂಟ್. Yes. The petitioner is before this court calling in question proceedings instituted by the disciplinary committee of the Karnataka State Bar Council on the complaint registered by the second respondent. The learned counsel for the petitioner submits that the second respondent is a habitual complainant, has registered a crime against the petitioner in crime number 58 of 2024 for offences punishable under section 323 and 504 of the IPC. The said crime has been stayed by this court. Stayed by this court in criminal petition 14201 of 2024, and the said interim order is in operation. After the grant of the interim order springs the subject complaint. The complaint is to the Bar Council on the score that the petitioner has abused the complainant with vulgar language, calling him monkey and donkey. Therefore, the Bar Council has taken up the complaint on the said vulgarity of language that is used by the complainant. I do not find any ingredient of professional misconduct as is necessary for the Bar Council disciplinary committee to take proceedings against the petitioner, albeit prima facie. Therefore, there shall be an interim order of stay as spread for emergent notice to the respondents. Yes, next. Saruda, yaru madam? Aden beda. Next.
48.
My lord, I appeal for the petitioner.
Prior notice kodadu, not idu, emergent notice. Learned counsel TP Vivekanand is directed to accept notice for R1. Lady yaro idralla madam, or R2? Yes, next. Yen Vijayant?
My lord, I appear for the petition.
BBMP tender
Idu BBMP.
Yenu garbage tender
For compensatory aforestation issued by Deputy Conservator of Forest. My lord, so wide annex.
Compensation for afforestation.
Compensatory afforestation. Wide annex area, my lord.
Yeah,
For my lord, for raising around a few thousands of samplings in pertaining to
Learned AGA, BBMP matrana.
BBMP.
Learned AGA is the BBMP assistant conservator of forest idara.
I was.
Allondide post idya.
There is even deputy conservator of.
Learned.
No, there is a tree officer.
Learned counsel, tree officer gottu. Learned counsel for the respondent, Learned counsel Pawan Kumar is directed to accept notice for the respondent. List the matter on 17. Petitioner to serve a set of papers, list on 17. Next.
May they not take any precipitative action, madam?
Idರಲ್ಲಿ ಯಾವ precipitative action?
The original contractor is dead.
No problem. 17. You know the matter if there is. You know the matter if there is anything. Yes. Yes, Rahul.
The notice has been issued by the Milord, the respondent.
An unauthorized occupant,
Hello, sir. It has been granted by 1947. I purchased this property and conversion order also been issued by the government.
The learned AGA is directed to accept notice for the respondents. Or copy idya? On the petitioner shall not be evicted if not already evicted, nor any precipitative action be taken qua the poultry of the petitioner.
Lordship already passed an order, an earlier matter. And
The same kolina?
Same property. Lordship has passed an order, not direct the.
No, chicken is protected. Yes.
Even though there is an order.
You ಆಯ್ತಲ್ಲ ಈಗ ಏನು? ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟ ಮೇಲೆ an argument. ನಾಳೆ.
ಅಲ್ಲ ಏನು ತೊಂದರೆ ಮಾಡ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗ್ತದೆ.
ಕೋಳಿಗ?
ಅಲ್ಲಿ ಆಲ್ರೆಡಿ
ಕೋಳಿಗೆ ತೊಂದರೆ ಮಾಡಿದ್ರೆ ತೊಂದರೆ ಆಗತ್ತಾ?
ಅಲ್ಲ ಕೋಳಿಗೆ ತೊಂದರೆ ಮಾಡೋದಲ್ಲ 18,000 ಬರ್ಡ್ಸ್ ಆರ್ ದೇರ್.
ಯಾವ ಬರ್ಡ್ಸ್?
ಕೋಳಿ ಬರ್ಡ್.
ಕೋಳಿ. ಎಸ್.
ಅದನ್ನ ತೊಂದರೆ ಮಾಡ್ತಾರೆ.
ಕೋಳಿ ಬರ್ಡ್. ಆಲ್ ರೈಟ್. ಕೊಡಿ. ಬ್ರಾಯ್ಲರ್ ಚಿಕನ್ ಮೊಟ್ಟೆ ಮಾಡಿ ಮರಿ ಮಾಡ್ತೇವೆ. ಆಯ್ತಾಯ್ತು. ಓ ಸರಿ, ಆಯ್ತು.
64 weeks is required.
ಬ್ರಾಯ್ಲರ್ ಸರ್. ಮತ್ತೆ ಫ್ರೋಸನ್ ಚಿಕನ್ ಹಾಗಾದ್ರೆ. ಎಸ್, ಇರ್ಲಿ ಬಿಡಿ, ನನಗೆ ತೊಂದರೆ. ಲೀವ್ ಇಟ್. ಎಸ್ ಎಸ್, ಬೇರೆ ಕೇಸಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಎಸ್.
In say number 50, the petition is an auction purchaser, Lordship. Sales certificate on 11/10/23. But have not been given physical possession. The bank's counsel. I'm only asking.
Responded, my lord.
You are the auction purchaser.
Please, members. With the help
Yes,
of-
government, sorry, yes, Indian Bank.
I have to respond, my lord. They are seeking police protection.
Police protection.
But the help of the jurisdiction.
If it is given, we will take the position and give it to me.
Where is the sale certificate ಆಗಿದೆಯಾ?
Sure, my lord. Page number 30.
What is?
I've served them a copy as well.
The learned AGA to secure instructions as to why why police protection is not granted to the petitioner
My lord,
for.
maybe just, it's only a mandamus. With the help
Madam,
of.
ತೊಂದರೆ ಏನಿಲ್ಲ. The petitioner is before this court seeking the following prayer. The heard so and so, the learned counsel, the petitioner is the auction purchaser pursuant to an auction conducted by the first respondent bank. The auction has become final in as much as the sale certificate is already issued and registered in favor of the petitioner. What has driven the petitioner to this court in the subject petition is the non-cooperation of the jurisdictional police with the respondent bank to execute the order of the magistrate taking possession of the property. The learned AGA submits that the jurisdictional police would look into the matter and render such police protection in accordance with law. In the light of the said submission, I deem it appropriate to dispose the petition, directing the respondent police to take action in accordance with law as is sought by the petitioner or the respondent bank, as the case would be, towards taking possession of the property, ordered accordingly.
Much obliged.
51.
Auction notice was published on
134. We'll come back. We'll come back.
Serial number 69, withdrawing the.
Thank you, sir. Lunch is over. Withdrawal in terms memo. Yes.
Malesh, and delivery memo, Malesh.
Yes, madam.
And delivery memo, Malesh.
69.
Yesterday or past order.
Yesterday order sign ಮಾಡಾಗಿದೆ ಬರುತ್ತೆ.
Swami, ಅದು action ನಾಳೆ ಇದೆ, Malesh.
ಅದು ತಗೊಳ್ಳಿ madam, ಅದು ನೋಡಿ. Yes.
69. Sandesh. Madam. Sir.